All right, good morning, everyone. My name is Arlisha Wilson. I'll be the chair of today's meeting, and we're going to go ahead and get started on today, November 3rd, 2025. Madam Secretary, you want to read the preamble?
Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, this Monday, November 3rd, 2025. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found on the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who provided written comment on a particular matter. Back to you, Madam Chair.
All right, thank you for that. Can we call the roll, please?
Sure. Mr. Madison.
Present.
Ms. Faith.
Excuse me, present.
Ms. Holzer.
Present.
Ms. Roca. Present. And Ms. Wilson.
Present.
Madam Chair, we have a full quorum.
All right, we have a full quorum. Nice. Do we have any postponements or withdrawals?
We do. We
Okay.
have 3 postponements this morning.
Ooh,
The first one is calendar number 25-140. This would be the second postponement. The appellants emailed us last week to state that they have had a death in the family and will need to be away for a couple of weeks for the for everything that goes along with that. So they need a postponement, and the next date available would be December 15th.
okay. So we will move that to December 15th. So if you're here for the case that's located at 6624 Harvard Avenue, we will not take testimony on that particular matter this morning. It will be postponed. Any other postponements?
Calendar number 25-184 at 863 Herrick. Teresa Wakefield, are you here? Yes, hi. So late last week, we received an email from the council person, and they would like a postponement to allow time for you to meet with them, and they would like you to get a petition, speak with your neighbors, as well as if there's a development corporation in the area, they would like you to do that as well, to meet with them. We can get you back on the agenda for December 8th.
All right, so that is calendar number 25-184. This is at 863 Herrick Avenue. So if you are present for that matter, it will be postponed. Okay, all right, so
That's
we will
great.
not take testimony on that matter this morning. Yep, you can return December 8th. At that time, we will hear testimony.
And we
Okay.
should also state, there was an issue with the adjudication that we are going to try to clear up. I don't know, Mr. Bay, would you be able to speak on that a little bit? I believe that it may be classified differently than a group home. And Building and Housing is aware and will be working on that.
That's correct. I think after my last conversation with Ms. Wakefield on the phone, she stated it wouldn't be a state licensed facility, that it's more of a rooming home. Just first allowed in a multifamily zoning district, and this property is in a limited family district. So the review that was done actually looked at the application as it was a group home, or more officially termed as a state licensed residential care facility, which is not the case after my last conversation.
So, Madam Chair, We will be waiting on an update from Building and Housing on the adjudication. So we will shoot for December 8th. We will be in contact if it takes longer to get that updated adjudication. But at this time, we can put them on December 8th.
Okay, is there anything they need to do for the adjudication in terms of reaching out to anyone, or should they say that again?
It's already been re-adjudicated, so whenever you guys want to put it on the calendar.
Oh, okay. Well, it's already ready. Okay.
Thank you.
All right, so December 8th, we'll bring this back on December 8th. All right, thank you all for coming down. Do we have any other postponements?
And there is the final one on the last page of the agenda. It's a calendar 25-152 at 4239 West 143rd Street. Samuel Rivera proposing to construct a 960 square foot garage. We have been working with him, city's been working with him on re-adjudicating his appeal as well. And we had to move him one more time to November 17th. Notices went out last week.
Okay, so this is at 4239 West 143rd Street. If you are present for this case, we will not go forward and hear any testimony. It will be heard November 17th. Does that conclude our
That-
postponements for
Yes,
this
it
morning?
does. Yes,
All
thank you.
right, thank you for that, Madam Secretary. So I will now, okay. I will now call calendar number 25-178. In fact, this might be a bundle. I'm not sure. We'll see though. Is there anyone on behalf of Douglas Baird present? Okay, perfect. We'll have you come up to the table. Uh-huh. All right. Anybody else present for 18200 Lorraine Avenue?
Yes, my neighbors are
Okay.
George and
Madam
Wally
Chair, we have
Cross.
received a request to consolidate the three cases.
Okay.
25-178, 25-195, and 25-199.
Okay. All right. We will hear all three of these cases together. If you're present for this matter, do come to the table. And while you do that, I'll have Ms. Hoser read in the case.
Wally and George.
The,
And I'm just waiting for the slides to be pulled up online.
I think she's gonna read them in. Yeah. What's that? Are there what?
He has recused. It's his employer.
So we have plenty of them.
He works for Cleveland Clinic.
Are you saying call a different case?
Yeah.
Okay. Okay. They're like at the table. Okay. So it looks like we're missing a few parties for this case. Oh. Okay. So we're gonna recall this case. Sorry to have you come up and get to the table. So we do have another bundle. Is that the number? Okay, so I will call,
Time, don't you forfeit?
fully understand that concept. Shannon has asked me to call a different case.
Figured you good for the other cases before the appeals, but it's up to you.
It actually would be interesting. This may, there's going to be extensive testimony in this week. Try to sit with us for a minute. We have just two cases.
Okay,
It's the West 11, there's one. from-
which is a bundle, right? Okay, all right. Sorry about that. We'll call you right back. All right, we'll go to calendar number 25-182. This is Adjacent Properties Corp. Do we have anyone present on behalf of Adjacent Properties Corp?
Yes, present.
Okay, very good. Thank you for that. I'll have Ms. Hoser read in this case instead. Ms.
Sure
Hoser?
thing, Madam Chair. Yep. Our first case is calendar number 25-182. This is at 11502 Ullman Avenue. Adjacent Properties Corp. or Corporation owner proposes to change use of an existing two-family residence to a three-family residence in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are, it looks like there's, is it 3 or 4? I'm reading number 3 and trying to, okay, it looks like it's 3.
Yes, it's
and with
3.
that- Oh, There are three. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, we will swear in all those who are present for this case. If you're in the room, please come forward. If not, we'll move right on to those who are online. Please unmute yourselves. Do you swear and affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please say your name, spell your name, provide an address for the record, followed by I do. We'll start with you, Tyrell.
Tyrell Perry, first name spelled Tyrell, last name Perry, Perry. I do.
And what's your address for the record?
4827 Dakota Avenue, Down Rear Apartment, Cleveland, Ohio, 44127.
Thank you. Is there anyone else present online that would like to speak to this case? Seeing none, Madam Chair, I'll turn it back over to you.
All right, thank you for that. Can we have history of the property, please?
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found that in 1916, a permit was issued to erect a 2.5-story dwelling. There are no variances on file, and in the more recent history, we see that in 2017, rental registration was issued to the property. 2022, a lead safe certificate was issued to the property. And then again in 2022, a rental registration was issued and a lead safe certificate was issued as well. And that's all that I have that's relevant. Thank you, Madam Chair.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is requesting a use variance and area variances from the minimum lot area and maximum gross floor area requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code. Under section 337.03C, the Board of Zoning Appeals, upon prescribing proper safeguards to preserve the character of the neighborhood, may grant special permits for the remodeling of existing dwelling houses or the erection of row houses to provide for more than 2 dwelling units, provided that, and the two applicable sections of this code are, number 1, the square feet of lot area to be allotted to each dwelling unit is in accordance with the area regulations included in chapter 355. And number 4, the building when altered or erected and when occupied will conform to all the applicable provisions of the building and housing codes as the Commissioner of Building and the Commissioner of Housing so certify.
All right, thank you for that. We'll now go to the project team. Mr. Perry, do you want to give your testimony?
Sure. So I acquired the property, I believe back in 2016 or 2017. And when I acquired the property, it was already erected in a current condition. It appears that the attic was converted into a 1-bedroom apartment. And I was unaware at the time that it was actually a 2-family property. So the unit has been rented for several years since I acquired the property, and there was no issues whatsoever. It has ingress, egress. It has a kitchenette area. It has living room area, things of that sort. It was at one point where I had some electrical work being done, and the commissioner, or I should say the chief, they came out, they approved everything, so forth and so on. So at this moment, I still wasn't aware that there were any deficiencies with the property. Fast forward to I would say last year, okay. So to 2024, the tenant that is in the unit, for whatever reason, they allowed their electric service to go off. Okay. When that happened, it was off for over a year. So after a year has lapsed, when there's no electrical service, then you have to have the Department of Building and Housing come out to the property and, inspect it and certify that everything is, up to snuff. When they came out, the inspector cited that it was a two-family. So once that occurred, I then had to go through the necessary channels to convert it into a three-family, which is why I'm attempting to, I'm appealing for a variance today.
All right, thank you for that, Mr. Perry. Any questions from the board?
Madam Chair, our usual question is, how many sets of meters are there?
There are 3 meters.
So it is metered for gas and electric on all 3 units.
So electric is metered for all 3 units. Then the bottom 2 units, they're metered for gas, and then the top unit is only electric. So the heating for the top unit is electric baseboard heating.
Okay. And do you have 2 means of egress for that top 3rd unit?
I do.
All right. That's all I have, Madam Chair.
All right, thank you for that, Ms. Faith. Any comments from city planning?
Good morning. My name is Xavier Bay, representing City Planning. We're in support of the variances requested today. This is an example of gentle density. Then the applicant's also not making any major alterations to the outside of the home, so that it falls in context with the surrounding properties. That's all I have to say.
All right, thank you for that, Mr. Bay. One last call to the board for any questions.
Yes, just Madam Chair, through you. Can you speak if the variance is denied today, what practical hardship, practical difficulty you might face?
Are you speaking to me?
Yes, that's a
Yes.
question for you, Mr. Perry.
Oh, okay. So if the variance was denied, then of course I would have to vacate the property. The tenant's been a longstanding tenant. He takes care of the premises, and then also it would reduce the income of the property as well. So that would be a hardship for me that I didn't see forthcoming, especially when I purchased the property. In addition, there would be, I guess for the county, it would be less income in terms of rental registration fees to that extent. And I believe that concludes.
Thank you.
All right, any other questions? All right, I'll entertain a motion.
Madam
Ma-
Chair, given the testimony we've heard today, I move approval for calendar number 25-182.
All right, thank you for that, Ms. Faith. Is there a second?
Board Member Roca, I second.
All right, thanks, Ms. Roca. Can we call the vote, please?
Mr. Madison,
Yes.
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Faith,
Yes.
Wilson.
Yes.
Calendar number 25-182 is granted. This will be ratified next Monday, and we will send the appellant the letter. He can also contact us next Wednesday for further instruction.
All right, Mr. Perry, you are all set. Thank you for being here today. We're now going to go to the next 7 cases that will be bundled. So if is anyone here for West 11th Street Properties? Anyone online from West 11th Street Properties?
Yes, Michael Tomsick, the architect.
Okay, perfect. Just wanted to make sure we had someone here. So now we're going to ask Ms. Hoser to go ahead and read in the cases that are a part of the bundle.
Sure thing. And Madam Chair, I am noticing that some of the cases have 4 code sections and some have 5. What is your preference on how I read these in?
I think however you see fit, just indicating, where the differences are.
Okay. So our next, let's see, 1, 2, 3, 4, 5, 6, 7. Okay. Our next 7 cases are regarding West 11th Street properties. So first we have calendar number 25-188. This is at 2850 West 11th Street. West 11th Street Properties owner proposes to erect a 4-story frame single-family residence with attached garage in a B1 2-family residential district. For this calendar number, we have 4 code sections to be considered. On calendar number 25-189, this is at 2854 West 11th Street. Again, West 11th Street Properties owner proposes to erect a 4-story frame single-family residence with attached garage in a B1 2-family residential district. For this one, we have 5 code sections being considered. On calendar number 25-190, this is at 2858 West 11th Street. Again, West 11th Street Properties proposes to erect a 4-story frame single-family residence with attached garage in a B1 2-family residential district. This one has 5 code sections being considered. On calendar number 25-191, this is at 2862 West 11th Street. Again, the appellant proposes to erect a 4-story frame single-family residence with attached garage in a B1 2-family residential district. This one has 4 code sections being considered. On calendar number 25-192, this is at 2884 West 11th Street. The appellant again proposes to erect a 4-story frame single-family residence with attached garage in a B1 2-family residential district. This one has 5 code sections being considered. We only have 2 more to go. On calendar number 25-193, this is at 2888 West 11th Street. Again, the appellant is proposing to erect a 4-story frame single-family residence with attached garage in a B1 2-family residential district. On this one, there are 5 code sections being considered. And then lastly, on calendar number 25-194 at 2892 West 11th Street, again, West 11th Street Properties owner proposes to erect a 4-story frame single-family residence with attached garage in a B1 2-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 5. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. At this time, we'll read in, swear in all those who are present for this case. If you are in the room and you would like to speak, please come forward. If not, we'll move on to those who are online. Do you swear and affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, say your name, spell your name, provide an address for the record, followed by I do. We'll start with Michael.
Thomas Michael Tomsick. Address 921 Literary Road, Cleveland, Ohio. I do.
And can you please spell your name for the record?
Tomsik.
Thank you. We'll move to the individual that has their hand raised. You can unmute and provide the same information.
Hi, can you hear me?
Yes.
My name's Carrie Merkin, Karimirkin. I'm at 2878 West 11th Street.
And please reply with I do, that you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth.
I do.
Thank you. Is there anyone else present online or in the room that would like to speak to this case? Seeing none, Madam Chair, I'll turn it back over to you.
All right, thank you. Can we have history of the properties, please?
Sure. Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found very little for these 7 addresses. We found something at 2850 that an addition to a residential property was erected in 1933, but then a residential structure was demolished in 1966. Then for the address of 2854, a permit was issued in 1967 to demolish a residential structure on the property. And then for the address of 2888, there was a dwelling erected in 1897. We did not see any other records after that. There are no variances on file for these addresses and nothing of note in the more recent history. Thank you.
All right, thank you for that. Can we have legal, please?
Madam Chair, members of the board, appellant is requesting area variances from the attached garage, maximum gross floor area, and front setback requirements of the zoning code. And 5 of the 7 also have an additional um, the area variance for the rear yard requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code. And then there's a note under section 329.04C, the board's authority is limited in granting a front yard setback variance.
All right, thank you for that. We'll now turn to the project team. Mr. Tomsick, you want to tell us about this project?
Good morning. These homes, 7 homes in clusters of 3 and 4, are single-family townhouse style homes. The lots, as you see, are small and narrow. We are actually abiding by the setback requirements, which may have not been evident on our original submission. So we do abide by the setbacks. One thing I would like to mention that we do have a front-facing garage door, but we also have the main entry door facing the front. The homes have a first floor footprint of 793 square feet. Small footprint, therefore we're building vertically. It is a total of 4 stories, with the 4th floor being optional future use rooms. So on the first floor, you have a garage, second floor, living space, living, kitchen, dining. Third floor, 3 bedrooms. And then the 4th floor would have future bathroom and bedroom or office.
All right, does that conclude your comment, Mr. Tomsick?
I believe so, until I'm asked to address any questions regarding the homes.
Okay, so let's start with the front yard setback. You mentioned that you are in fact complying with that code section. Have you submitted an updated drawing to reflect that you are compliant?
We did. Well, I caught it yesterday and emailed it to the General Board of Zoning Appeals email address. And I believe that the site engineer had already indicated the appropriate setbacks.
Okay, thank you for that. Any other questions from the board?
Madam Chair, could the appellant confirm that these revised drawings that we just saw this morning, that there are no other changes other than to the front setback?
That is correct.
Okay,
Madam Chair, there are rear yard setbacks as well. To the appellant through the chair, are you stating that you comply with those as well, or just the front yard?
Just the front yard setbacks. We would request a variance for the rear yard.
okay, that is noted. Any other questions from the board? All right, any comments from Mr. Bay on behalf of city planning?
Good morning. I don't believe we've seen the revisions. I'm actually defer to Shannon Leonard if you've seen the revisions yet.
We have not seen the revisions yet. I know it was just the conversation that you had with Mr. Domsick, Xavier.
Yeah, I did have a conversation with Mr. Tomsick. We're explaining the front yard regulations here and how on the site plan you see on the screen, there's a 9-foot dimension listed from the front yard property line to the footers of the homes, which actually uphold kind of the rest of the structure like a balcony or cantilever. And so I believe if Mr. Tomsick's regarding the 9-foot dimension that's listed, labeled on the plans to meet the setback, I don't believe that's correct. Because those footers are holding up the rest of the building.
Okay.
There is a larger dimension he has listed on the plans. If you could actually zoom in a little more, you can see where the actual front of the garages are. But we were taking the dimension from the actual footer that's labeled the 9 foot.
Mr. Thompson, any response to that?
So on the revised plan that I did email yesterday, which I apologize for it being a Sunday, those dimensions are corrected for the appropriate setbacks.
All right, so it looks like there may not have been enough time for those drawings to get where they needed to go. I'm going to now ask for comment from Carrie Merkin.
Hi, this may be a moot point, but my main concern, and I live right next to the proposed units, is that the setback was so much shorter than is required. So it sounds like maybe that's not an issue. My other issue is that the square footage is more than twice as much as the 50% of the lot size. So it just sounded like this property was going to be too big and too close to the street for the character of the rest of the street.
Okay, and are we correct to assume that your concern with the setback is the front yard setback?
Yes.
Okay, so it sounds like that has been revised. So based on that revision, do you have any change in your thoughts, or do you have any additional comments based on that?
Just again, the other houses, including mine, can fit at least 2 cars, well over 2 cars length in front of the house. I don't know all the specifics of what the setback means in terms of, you were talking about a balcony. So just saying that seems to me too close to the street, compared to all the other houses on the street. But I'm not, I don't have the drawings and I'm not an expert, so I could be wrong about that.
Okay, so it sounds like the revised drawings will address what your concern, the concern you're expressing today. So thank you for being here and thank you for giving your comment. Any questions from the board?
Yes, Madam Chair. Through you, can the appellant please share with us if the variance is denied, what practical difficulty will they face? This will be
It
to,
would be, hello. It
We can-
would, okay, I'm not sure. Yeah, I'm unmuted. Okay. It would be difficult to build on these small lots, homes that are marketable for this area. We are adjacent to a small apartment building which has mass and size that makes it such that these homes do not seem like they are overwhelming the street and the site. The ability to have garages on the lower level, first floor, facing the street allow for these homes to be marketable.
Thank you.
If we could not have garages, then the homes would not be marketable. In the size, current homes in the Tremont area generally are 3 bedrooms with large living space with the ability to be vertical. So the client is asking that these homes match the current marketable homes in the Tremont area.
All right, thank you for that, Mr. Thompson. Any additional questions from the board?
Yes, Madam Chair, I have 2 questions for the appellant. Can you testify as to why the garages cannot be in the rear yard? That's my first question. And second question is, have you gone through the design review process, or has this been approved by, these are townhomes, so they have to go through city planning approval, correct?
To the chair, these are actually, this is Xavier with City Planning. These are actually single-family homes. They're all detached, single-family homes.
And I misspoke. Thank you for that. So design review then.
Yes, sir.
Yes, these have appeared before design review.
And they were approved?
Yes.
Okay, and then the second question with the garage, can you testify as to why the garages cannot be in the rear yard?
The topography of the land is a hill in the back, and the lots being very narrow, it would be difficult to have a narrower house allowing for a driveway to go to the rear. But when I reference the hill in the back, we would not be able to build a garage into that hill in the rear of the property.
Thank you.
All right, any other questions from the board?
Madam Chair, I do have a question.
Yes.
And I'm sorry if I missed it. Could the appellant give us the exact dimensions on the record of the new setback? And you mentioned a cantilever. Could you give us the, I guess, the footers and the cantilever measurements?
Yes, I will. So the first floor footers, and there is a slight jog in the floor plan. The nearest footer to the front is 13 feet 3 inches. Then the inset footer is an additional 18 inches. So the closest footer would be 13 feet 3 inches.
All right, does that answer your question, Madam Secretary?
And also then the, did he say the cantilever? Then what's the distance of the cantilever from the street?
Okay, so then the upper floors are 9 feet. In other words, the floor plan, the cantilever.
Excuse me, Madam Chair.
Please.
This is Xavier Bay again. I'm opening the document to make sure that this checks out, and it looks like the 9-foot measurement still is labeled from the front parcel line to the footers. So I'm not sure if it's the wrong document but the front yard setback requirement would still not be met.
You may be looking at the wing walls that support the upper floors, and those are at 9 feet. But the first floor setback is 13 feet 3 inches.
Madam Chair, I would just recommend you can't grant the front yard setback here. So just take that out of any motion and condition that a proper site plan is resubmitted.
Okay, that is noted. All right, any other questions or comments from the board? If not, I'll entertain a motion.
Given the testimony we've heard today, we've had Mr. Tomczak before us before, and I think with a similar cantilever situation. So, with everything we've heard today, and with the condition, of course, that they do need to submit plans, updated plans, since we don't have them before us today. Excuse me. I move approval of the 7 cases in this bundle, 25-188 through 25-194.
Madam Chair.
All right, thank
I'll
you for
make a
that,
friendly
Ms. Fay.
amendment. I'll second the motion and make a friendly amendment that we are conditioning the approval on the basis that we cannot approve the variance for section 357.04A at this time.
Okay, so we have a motion on the table that is seeking to approve the variances with the exception of the front yard setback. And it sounds like, Ms. Roca, you have seconded that motion, given your friendly amendment. Can we call the vote?
Mr. Madison?
Yes.
Ms. Holzer?
Yes.
Ms. Roca?
Yes.
Ms. Faith?
Yes.
Ms. Wilson?
Yes.
Calendar numbers 25-188 through 25-194 are granted conditionally, noting that the front yard setback variances are not granted. Will we hold ratification or will we just allow him to submit? We want a copy of
I
the
would say
revised
hold,
site
and then
plan.
do we need to take a vote on the denial of the front yard setback variances at all,
I
or
wouldn't think we would have to do that
No.
separately.
just, okay,
No, we will make sure that the resolution reflects that that code section has not been approved as part of
Okay.
this variance.
perfect.
And then we will also mention the revised site plan in the, so Mr. Tomsic,
Okay.
we will hold ratification until we get a good copy of your revised site plan. So please submit that to me.
All right, then my question is, I'm reading on the documents mailed to me regarding this meeting. Please tell me again the item number of the setback that is not being voted on at this motion.
We are not
Um,
voting on the front yard setbacks in any of the cases.
357.04.
Correct.
Okay, so then what happens with that item with setbacks? Once you see that we do abide by 13.7, then that item then is null?
It will be removed from the
From the
description.
application, yes.
So the resolution will not show that language on it, and so that's what's
Okay.
delivered back to building and housing.
And
They'll
that's
see
just-
that you were
All right.
granted 3 or 2, because the 4th is the city planning issue
Right.
as well. So they are technically being approved with the first one, just the first 2 this first 2 items. And so the resolutions will reflect that.
Thank you, that does clarify it for me. Thank you very much.
Okay, you're very welcome. Good luck with your project.
Thank you, we all appreciate it.
Absolutely. All right, so now we are gonna recall. Let me do it. Calendars number 25, 178, 195, and 199. This is at 18200 Lorraine Avenue. So will the appellants please come forward? And while you do that, we'll have Ms. Hoser read in the case.
Our next 3 cases are calendar numbers 25-178, 25-195, and 25-199. These are administrative appeals for 18200 Lorraine Avenue. And again, it's an appeal of the City Planning Commission decision in regards to this case. We have Douglas Baird, Walter Grossman, and George L. Gores et al. Appeal under the authority of Section 76-6 of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the City Planning Commission to award final site plan approval on September 5th, 2025 to the Fairview Hospital North Campus expansion as described in City Planning Commission case FW 2024-14. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellants fail to meet this burden, the administrative decision must be affirmed. And with that, I will hand it over to Mr. Madison for the oath.
Thank you, Madam Chair. I will have to recuse myself from this case, given a conflict of interest.
Okay,
I do so at this time.
we'll still have you just do the oath and then you can forego your
Madam Chair,
vote.
while we're recusing, I also have to recuse myself due to a conflict with my employer.
Okay, so then you're down to 3 board members voting on your case due to the recusals, just so that you're aware.
There was an issue that I spoke to the secretaries about. We do have PowerPoint. And
Okay.
yeah, could you,
Mr. Bay, are you able to open their PowerPoint that was sent to us for the event?
There was an issue and document was sent through.
Your mic is off.
All right, thank you. The document was sent through Google Drive, which isn't too compatible with our services here. So I did have issues downloading the document.
Use a USB.
It's up to your discretion, yeah, if you want to Try to upload a document now, we can.
Okay,
Okay.
any opposition from the voting board members regarding that? All right, why don't we go ahead and use the USB?
Okay. And we do have another presenter that really should go in between us.
Where is the other presenter? Okay, yeah, you
So-
can come forward,
so the
absolutely.
The order would be Douglas, Katie, then me, and
Okay,
then George.
okay, perfect.
Name for the record. His name for the record, please.
What's your name, sir?
Walter Grossman.
Okay,
Would you like me to start swearing in?
yes, please.
So at this time, we will swear in those who are present for this case. We'll start here with, and then we'll move to those who are online. If you would like to speak, just raise your hand and we'll come to you following the swearing in of those present. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please say your name, spell your name, and provide your address for the record, followed by I do. We'll start here with you. I'm sorry, wait 1 second. And if you can just hit the green yes button there, that means your mic is live.
I do, and my name is Catherine Shepherd, CATHERINESHEPPARD. My address is 17612 Aileen Avenue, Cleveland, Ohio.
Thank you.
Douglas Baird, DOUGLAS, last name BAIRD, 31675 Lake Road, Bay Village, Ohio.
And I do.
I do.
Thank you.
Walter Grossman, WALTER, GROSSMAN, and I do.
Thank you.
My name is George Gorze, GEORGE, I live at 3747 West 179th Street. And I also operate a business on the corner. The address is 17902 Lorraine Avenue. And I do.
Thank you. We'll move over to those who are, I see City is represented here. We'll move over to you all here to swear in.
Shannon Leonard, Chief Zoning Administrator.
Callie Mersman, Director, City Planning.
Robert Mavick, Commissioner of Division of Traffic Engineering.
Charles Slife, Councilman, Ward 17.
Thank you.
Tricia McGinty Aston, Assistant Director of Law.
Thank you. And we'll move to those who are online.
Do they say I do, so we know they're telling the truth?
Yes.
I do. I do.
Thank you.
Thank you. Those who are present online, I can't read the name there. Is it Barbara? You can unmute yourself. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? Just please say your name, spell your name, address for the record, followed by I do.
I do. My name is Barbara Haas, BARBARAHAAS. I live at 3706 West 179th Street in Cleveland.
Thank you. Is there anyone else present online? Is there anyone else present here in the room that would like to speak for this case? I'm seeing none. Madam Chair, I'll turn it over to you.
All right, thank you for that, Mr. Madison. Can we go to history of the property, please?
Madam Chair, this is an administrative appeal, so we do not.
You're right about that. Thank you so much. Legal, please.
Madam Chair, members of the board, appellant is appealing a decision of the Cleveland City Planning Commission. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
All right, thank you. We'll go to the project team. Who would like to start first?
I'll start.
All right, state your name and then go right ahead and give your comment.
My name is Douglas Baird, and I've been a property owner at 3700 West 179th Street. My family and I for over 30 years. We are not attorneys. We are doctors, small business owners. We're owners, retirees, city employees, mothers and fathers. We don't know every line of zoning. code, but we know when something is wrong. We know when the neighborhood we've invested our lives in is being allowed to erode, decay, and be erased. This for institutional convenience over residential protections. We recognize and support the growth and the continued success of Fairview Hospital. It benefits the larger West Park community, but their success must not come at our neighborhood's expense. We deserve to thrive also. I apologize for my voice. I have a lot of throat problems. Let me state clearly, we do not oppose the rezoning of the parcels to institutional research. The issue before the board is not a classification of land use, but the continuity of protections. Our neighborhood deserves that protection. The 2010 BZA resolution, which we fought for and won from your predecessors, was attached explicit conditions to the same land, conditions that continue to remain binding. Under Cleveland Codified Ordinance 329.02D, the conditions imposed by this board in 2010 remain binding until the board itself modifies or rescinds them. Neither city council, nor planning, nor the law department has the authority to nullify those protections through rezoning or site plan approval. The city law department has attempted to recast our appeal as opposition to rezoning. It is not. Our position is that no zoning action extinguishes this prior BZA condition. The residents of our neighborhood are not here to dispute progress, but to ensure that progress respects the rule of law and promises already made under this board's authority. The Board of Appeals is our last safeguard to that balance. We ask you to enforce the precedents and conditions your predecessors established to restore fairness to our neighborhood, which is now under siege. You can see our neighborhood here, Fairview Hospital across the street, and when we once had homes on both sides of West 179th Street. Fairview Hospital's northward sprawl has been slow, deliberate, and corrosive. It has not been the course of natural growth, but the methodical dismantling of our residential district. Homes purchased by the hospital, we can go to the next slide, were left to decay, suppressing neighborhood property values, suppressing resale potential, and eventually demolished. The loss of a structure is not just the loss of a family, it's the loss of a neighbor on our street. We can go to the next slide. And the next. We have attended every planning commission hearing. We submitted written testimony raising these same concerns, which I bring before you today. Yet our submissions were not addressed. The public comment confined to time-limited briefs. The hospital and city have repeatedly cited community engagement meetings. Yes, those meetings occurred. but to call them engagement is misleading. We attended every one. We spoke clearly, repeatedly, and on record in opposition. To hold a meeting and disregard the outcome is not engagement. It is performance. It is a public relation exercise disguised as dialogue. The hospital touts that it reduced the height of the medical office building by 1 floor in response to community feedback. The removal of one administrative level was not a concession to our neighborhood. It was a message to our councilman that if this hospital is not given what it wants, it will relocate services elsewhere. This is not community partnership. That is leverage. The selective rezoning of part of West 179th Street does not remove the fact that the remaining parcels and the majority of our district attain their 1F A1 zoning. This is supposed to denote the most restrictive typical residential zoning for a single-family home. Our neighborhood has not changed its character. It is being erased. The board's mandate is not to serve institutional efficiency, but to uphold the integrity of residential district. This slow conversion of a living street into a hospital corridor is exactly the type of erosion zoning law exists to protect. We can go to another slide. Oh, sorry. And another. We asked the board, wait a minute. The 2010 Board of Zoning Appeal imposed binding conditions to protect our residential district along West 179th. It required a masonry wall, permanent landscape buffering to separate institutional and residential zones, and it required entrance to and exit from the lot were to be located so as to do the least harm to the residential district. These were not gestures of goodwill. They were enforceable land use conditions under Cleveland Codified Ordinance 329.02E, which states that any condition imposed by this board shall remain in effect until modified or rescinded by this board. No such modification or rescission has occurred, no public notice, no hearing, no vote. The Planning Commission and City Council cannot just nullify through administrative rezoning or site plan approval what this board has imposed its authority upon. Can we see the next slide? Oh, wait. To disregard those still binding conditions, it's not merely a bureaucratic oversight. It is a procedural and substantive violation of the law. This project, as approved, ignores the 2010 requirements, the protections our neighborhood fought for and obtained, and renders them meaningless under a 995-car, 6-story parking garage. The precedent set in the River Edge Resolution Ordinance, further titled an emergency ordinance authorizing the mayor to enter into a memorandum of understanding with Fairview Hospital relative to their expansion plans, demonstrates that the city and Fairview Hospital have acknowledged this principle before, that institutional expansion into a residential area causes measurable harm, and that harm requires mitigation. We ask this board to apply the same principles that protect the River Edge residential area to the south of Fairview Hospital to our area as well. No hospital traffic should be allowed on West 179th, West 178th, West 176, or Aline Avenue. Institutional traffic must be confined to the hospital's property. The institutional traffic must be located to do the least harm to our district. The Aline Court right-of-way. You see it here. This is a public right-of-way that has been in place since our development was founded. It cannot simply be absorbed into the clinic circulation pattern. It is also a right-of-way that leads onto my property and behind all the homes. It is undeveloped, but it exists as a barrier between institutional and residential areas. And it needs to be upheld. Permanent screening. These are our backyards. That's Barb Haas's deck, my backyard from the bedroom window. I have asked repeatedly about the medical office building, which will now rise 85 feet, 65 feet with windows. And then the rest of it is a windowless penthouse. They're going to be looking directly into our backyard. We ask for a hedging, evergreen something to protect our residential space, our private backyards. It was completely disregarded. The hospital acquired the home at 3716. You can go to the next slide. They acquired the home at 3716 West 179th Street when the owner, the first house on our cul-de-sac, who had lived there for 25 years, objected that he was going to have an enormous structure built right next to his home. He said, buy me out. He had just spent over $80,000 renovating his home, from a new basement, new windows, new bathroom, new roof, having it painted. So the hospital obliged, and now they own yet another property on our street. In the River Edge ordinance that protects the South Campus, they required the hospital to resell residential properties. Upon completion, this house is now being used as a landscape or as a construction office. At the completion of this project, they should be mandated to resell that to a resident. We do not need more encroachment into our residential areas. You can see on the right, the green buffer zone. This is where 8 houses once stood. George's house is the lone home that remains in the middle. They tout this as being a buffer for the people on 178th and Wally's house on Aline and the rest of us. But it's not permanent. This is just a place card for future development. This will become a drug treatment center or God knows what they plan for our neighborhood because we have no protections. There needs to be some type of covenant or deed restriction that makes this green space being touted as a neighborhood amenity permanent. Look at the next one. All we've had is value removed. That's the home. You can see how close it is to all our houses. This house is now the construction office. And it comes right next to Ann's house, right next to Barb's house, right next to my property. And the hospital simply lets them fall into disrepair, rot, and then uses that as justification to tear them down. And we pay the price. We have had to live with decrepit homes all up and down 179th Street, the hospital monitoring them to see how much they have deteriorated. Broken windows, falling garages, everything. And then they say, oh, we're bad landlords. We're going to tear the homes down for the sake of the neighborhood. Well, it's not for our sake, it's for their encroachment. The Planning Commission has already sided with institutional convenience. This board stands as the last tribunal for fairness between our neighborhood and erasure. We're not asking for special treatment. We are asking that you respect the law set out in 2010 and that our values be restored. We can see it. Slide. This is what we lived with. Decrepit homes, trash, broken garages falling down, dead landscaping on the BZA mandated wall. And we were told, oh, there's nothing we can do about the landscaping once we sign off on the construction. So that's what we live with. When we call and complain about the state of the homes, oh yes, no one can do that till they find out they're owned by the clinic. Nothing happens. Next slide. This is what the neighborhood looked like on the left. That's what they've left us. Wally's house on the far right there. Bottom picture peeking out from behind the rubble. And this is the River Edge ordinance, which was put in place by the city to protect that district. We need the same. They had an open surface parking lot. We're getting a 6-story, 1,000-car parking garage, and nothing is returned to our community in the way of value. It is only taken away. We ask that there be no traffic. This is 178th. They will be the next to fall. Preservation of the Elaine Court public right-of-way. Requirement that they have to maintain evergreen hedging and screening. We need that green space made permanent with a binding maintenance and restitution, because we have no recourse once they let everything go to hell and we're forced to live it.
All right. So conclude your comments?
That's it.
All right. So we now have Catherine Shepard. You want to go ahead and give your comment?
Good morning. My family and I live at 17612 Aileen Avenue. We love our neighborhood, but rightfully we're concerned about its future with the Cleveland Clinic's continuing expansion. 15 years ago, the clinic purchased the homes on the west side of West 179th Street and replaced them with a parking lot surrounded by a 10-foot brick wall. I do apologize for the repetition, but we're passionate. At the time, clinic leadership promised to be good neighbors and assured residents that they had no plans for further expansion. Yet even as they made those assurances, they quietly began buying every home on the east side of West 179th except one. Since that expansion, our neighborhood has carried the burden. We've endured low-flying aircraft directly over our homes, constant noise, and the daily view of a brick wall surrounded by dead trees, tangled wires, and litter, empty cans, liquor bottles, styrofoam containers, bandages, and even used needles. 3 years ago, during Christmas break, my daughter and I cleaned up accumulated trash. A few weeks ago, my son and I did it again. Perhaps worst of all, the clinic allowed the homes it owned on the east side of West 179th to decay to the point of becoming public nuisances and health hazards. Broken windows, severe water damage, mold, bricks, and gutters on the ground. collapsing garages, with some tenants still living in them. A video we've provided and hope to share documents these conditions. When a complaint was filed, a Healthy Homes Initiative representative initially agreed action was needed, but apparently once he learned who owned the properties, nothing further was done. Now the Cleveland Clinic has been approved for another major expansion, one so large it doesn't fit on their existing property. They want the city to vacate West 179th Street and turn a public tax-supported road into a private driveway for a 995 car garage. For the families who live here, this feels like yet another disregard for our neighborhood, a community that's already given up so much for the clinic's expansion. As stated at the first City Planning Commission meeting, if the footprint doesn't fit on their property, it should not be approved. In 2010, the BZA determined that access to any new parking garage should remain on clinic property, even if that required an additional story to reduce the footprint. The board also required that the parking lot be enclosed by a 10-foot brick wall with specific landscaping to buffer the neighborhood. The clinic complied initially, but over time the landscaping declined and the trash returned. That pattern of neglect makes it hard for residents to trust new promises. We invest in our homes and care deeply about this community. We want to feel confident that our neighborhood will remain safe and residential, that our properties will hold their value, and that our children can grow up here without the constant fear of what the clinic might do next. West 178th Street is never a safe way out of the neighborhood. West 176th Street is only safe during limited times during the day. And West 179th is the only consistently safe route that we have left, and giving it up to a constant stream of two-way traffic would endanger every resident who relies on it. So I'm asking you on behalf of my family and the many working families and neighbors who couldn't be here today, the people raising their children in this quiet residential community where kids ride their bikes, people walk dogs, kids walk to friends' houses, and we all look out for one another. Please protect our neighborhood, keep it safe for the families who live here, and ensure that the Cleveland Clinic remains on its own property and acts as the responsible neighbor that the city deserves.
All right, thank you for that. We'll now go to Walter Grossman.
They have this up with you.
Yeah. Okay, I guess you, yeah, okay.
And then if you could speak into the microphone and speak loudly so that our court reporter to my left can hear you.
I have here what I submitted as Exhibit A in my submissions already. I have the actual petitions that were signed by the residents regarding this.
Okay.
Yes, these are the originals.
The originals from what date?
Well, that goes back to after the second planning commission meeting.
It's what the law department stated. They're not relevant because he listed the names on his submission, but didn't actually have signatures. So he's providing the actual sign.
I see Ms. Aston standing up.
I'm loud enough for everyone to hear. At the pleasure of the board, I know you'll accept it, but we object. Thank you.
Okay.
Okay.
All right, go ahead and give your comment.
Okay. I neglected to give my address up front. I live at 17810 Alene Avenue. We've lived there for 41 years. We've lived there for 41 years. And following up what Katie just said, I'm 81 years old. My wife is 72. Since we've lived there, my wife has never left our neighborhood through any other street but 179th, because that is the only safe egress from our neighborhood. And that's a very important issue. Now, as the meetings sponsored by CFS, Cleveland Clinic Foundation, revealed their planned expansion, several questions came up as to how CCF would handle the traffic flow from the new facilities. Stop touching. I was a clumsy child. Okay. The question questions kept coming up as to how are they going to handle the traffic patterns from the new garage? Every time the question arose, their standard answer was, we'll just have to wait for the traffic study to be done before we can answer that question. A short time later, the residents of the neighborhood received a notice that there would be a meeting with a traffic engineer at the West Park Library on April 29th, 2025. At that time, traffic engineer Robert Mavick addressed the attendees with the results of the traffic study. He presented several diagrams of essentially the same thing, all of which were unacceptable to the residents in attendance. All the traffic to and from the parking garage was to be directed to West 179th Street, with or without termination of 179th Street at Alene Avenue. That's a very, very important issue. When asked about the impact on the neighborhood, the remaining houses on 179th and the business on the corner of Lorraine and 179th, George's business, his answer was he was not commissioned to take that into consideration. He further explained, I was only directed to determine whether the use of 179th for the parking garage traffic was better than directing the traffic directly onto Lorraine Avenue. And he said it was. When he was asked about the impact on the rest of the neighborhood, he said he wasn't directed to consider that and didn't look at that effect on the rest of the streets. I tried to obtain a copy of the traffic study from the CPC, Planning Commission, and was referred to Mr. Mavick. But I was also told that it might not be available to me. I then emailed Mavick with my request. The return answer was unhelpful and, to be honest, almost unintelligible, something about they might be still working on it. Then I contacted the BZA and was told that a traffic study was a matter of public record and should be available from the Public Records Office. Unfortunately, the Records Office had no record of the traffic study. At least 2 other residents requested copies of the traffic study with no success, and these residents are here today, one of which is Katie. One of the residents was told no record, such record exists. The other resident, Katie, tried to get a copy via Councilman Slife. After an appreciable delay, the response she got was, quote, Commissioner Mavick knows about it as in contact with the CPC staff. Again, no copy of the study was provided. On September 22nd, 2025, I submitted a formal request to the Cleveland Public Records Center requesting a copy of the traffic impact study done at 18200 Lorraine Avenue regarding the Cleveland Clinic Fairview Hospital expansion. That's a copy of the receipt that I got. And my return receipt states, your request will be forwarded to the relevant city departments to locate the information you seek and to determine the volume and any costs associated with satisfying your request. You will be contacted about the availability and/or provided with copies of the records in question. And that I submitted as Exhibit F. A month later, on October 20th, I received a notice from Cleveland Public Records stating that the city had reviewed its files and has determined there are no records that are responsive to your request. And that would be the next slide. Exhibit
That's it.
G, that's it, okay. Okay. Cleveland regulations state, in Cleveland, a valid traffic study is considered a matter of public record. Public records in Cleveland are defined as any document created or received by a public office that documents the organization's functions, policies, decisions, procedures, operations, or other activities of office. This includes traffic studies, which are part of the activities documented by the public office. Therefore, the public has access to traffic studies conducted by the city, ensuring transparency and accountability in traffic management and planning. Information from the Cleveland Clinic states, traffic studies conducted by the Cleveland Clinic are not publicly accessible. This study was not made public, and the Cleveland Clinic's commitment to patient confidentiality means that such information is not available to the public. Regulation 337.14, location of required off-street parking space. The Commissioner of Traffic Engineering and Parking has caused a study to be made of the proposed location and finds that safe and adequate access can be provided and that the potential traffic will not be injurious or detrimental to the adjoining streets. Now, this ordinance, I will admit, refers to parking space auxiliary to another parking area. It must be assumed in a case like this that the original area was licensed after an adequate traffic study was performed. In any case, the procedure described in 337.14 is certainly appropriate in the CCF expansion case. Conclusion, a valid traffic study was never done. There is no publicly accessible traffic study. Under Cleveland's site plan review and BZA procedures, any major institutional project normally requires a traffic impact study, TIS. If the developer, the hospital, has not provided one, or if it has not been made public, the city cannot make an informed determination about whether the proposed egress protects the public safety and neighborhood welfare as required under 329.03, standards for BZA review, and 349.10, planned institutional development area. Without a TIS, the city would be approving access without evidence. Without that data, the city cannot demonstrate that it is protecting adjacent streets, districts as required by 337.02 and 349.07. There are adjoining residential protections. Under the residential district zoning rules for the city of Cleveland, even if a hospital is in a separate district, when a non-residential use, such as a high-volume garage, abuts or uses a street heavily encompassed by a residential zone, the city has authority to impose conditions to protect the residential zone. Since the hospital plan for exclusive access via a residential street compromises the subdivision's safe egress to Lorraine Avenue, impairing resident mobility, emergency access, neighborhood integrity, this triggers the adjoining residential area protections in the zoning code. If the hospital is unable to provide a satisfactory traffic ingress-egress plan that protects the subdivision's safe access to Lorraine Avenue, the city should require alternate access on its own property. Now, there's a very important point here. As I mentioned before, if 179th is blocked off from Alene, or if it's not blocked off from Alene, things change drastically in either case for our subdivision. And according to the plans, as I understand, this 179th, if it's given to the hospital, will stay that way without being blocked off from Alene for a period of a year before it can be reassessed to determine whether or not the street should be blocked off. And to us, that's a major, major factor. Okay, zoning limits. If the majority of the street is zoned one-family residential, that portion of the street is subject to residential zoning restrictions, commercial use, parking, etc. If a smaller portion of the street is zoned institutional research, the institution's zoning rights typically apply to the property zoned for the institutional research, not the entire street. Property zoned residential maintain restrictions even when adjacent non-residential districts such as IR. The rights granted to the IR parcel do not extend automatically across the street to the neighboring parcels that are zoned residential. So the way things are designed now, the IR zone on one side of the street is directly across from a residential zone on the other side of the street. In other words, the hospital has the authority, according to the way the plan is now, to occupy both sides of the street. Street use and public rights. Most streets are public rights of way, meaning anyone can drive on them. However, zoning can restrict the type of traffic that's generated by an adjacent property. Zoning laws usually cannot grant an institution exclusive use of a public street. Even if it borders the institution, traffic from the institution must comply with the limits designed to protect residential areas. Partial institutional zoning impact. If only a small portion, about 25% in this case, of the street is zoned institutional, the city may allow reasonable amount of traffic associated with the institutional use to enter and exit through that portion of the street, but it cannot legally force the residential portion to bear an enormous amount of traffic if doing so violates residential zoning protections and safety. Zoning on an adjacent parcel, such as IR, does not grant exclusive rights over the entire street. The public right-of-way remains under city authority, ensuring residential protections cannot be overridden. 411.011. Bottom line, the institution can't legally claim the entire street for all its traffic just because part of the street is next to institutional traffic. Traffic through residentially zoned areas is limited by zoning rules designed to protect residents. Based on Cleveland's zoning code, an institution located in an institutional IR district cannot use the entire street for all of its traffic, parking, or driveway access. The residential district receives protective conditions, thus enforces that zoning and parcel specific, and the residential side retains enforceable protections. 349.13. Cleveland employs a zoning system where each district has a specific permitted use. As an IR research district, certain uses are permitted. Main uses such as hospitals, medical clinics, medical office, medical institutions. However, these permitted uses apply only to the property within the IR district. 340.02, permitted main uses. They do not extend to the public right-of-way, such as the street. 3109.03. The residential zoning on the opposite side and remaining portion of the street imposes restrictions to protect the residential character of the area. These protections are typically include limitations on traffic volume, noise, and other factors that could disrupt the residential environment. Institutional uses should not be permitted to generate traffic that exceeds these limitations. With cameras, the city determined that there were approximately 200 cars a day using West 179th Street, which is normal for a subdivision of this size. After completion of the proposed garage, it is estimated that between 4,000 and 5,000 cars a day will be using 179th Street. There's no way that this scenario can be interpreted to conform to the letter or spirit of the laws protecting our residential district. Incidentally, there's a few houses on West 176th Street that are multifamily. All the rest are single family. Zoning code protections. Driveways from residential districts to a residential street are only allowed traffic that will not change materially the existing character of the street, nor be detrimental to the adjoining or adjacent residential areas. And that's traffic from a residential source, let alone institutional source. If the projected volume jumps from 200 cars a day to 400 to 500, 1,000 cars a day, that is a material change and a detriment by any reasonable standard. Street classification requirement. The code requires industrial / institutional exit onto a major thoroughfare unless the BZA finds no neighborhood harm. West 179th is not a major thoroughfare. Therefore, they need BZA approval, and BZA must deny if traffic harms the neighborhood. If CPC approved the plan without writing the access question to the BZA, that's a procedural flaw. And regarding the CPC, this is an aside. After the September 5th hearing, as we left the room, one of the commission members was also leaving. Some discussion was going on in the hallway, and I asked him if he realized that he just may have voted in violation of a city ordinance. With a surprised look on his face, he said no. Then I asked him, did you read any of the material that I submitted prior to the hearing? He said no.
City objects to that.
Objection is noted. Okay. Does that sum up your comments?
No, I got a little bit more.
Okay, briefly, please.
Yeah, well, this is the bulk of our appeal.
Okay.
Residential subdivision rights. West 179th is not just any street. It's the only safe egress street for an existing residential subdivision. Ingress, egress obligations for existing residents must be observed. Increased traffic can violate duty of care owed to existing residents. A small interior residential street is not structurally designed for 4,000 to 5,000 cars a day. If the engineering was not structurally designed, if the traffic engineering was not fully completed or reviewed, this is grounds for reversal or conditions. The city is effectively turning a residential street into an institutional driveway, which exceeds its police power, authority, and constitutes unreasonable interference with residential property rights. And bear in mind, there's a family with 2 children living directly across from the IR zone, where thousands of cars a day will be streaming across the front of each house every day, of that house every day. We are not opposing the hospital's expansion, although it will damage the desirability of our neighborhood. We are not opposing the zoning change. We are opposing the reckless traffic placement that threatens the residential safety and violates zoning requirements meant to protect neighborhoods. There are alternative access points on the clinic's campus. Choosing to destroy this street is a choice of corporate convenience, not public necessity. Cleveland's IR zoning code only permits access onto a residential street if the traffic will not materially change the existing character of the street or be detrimental to adjoining residents. Now, there's effects here on the neighborhood's morale. It is incredibly frustrating when large institutions have political leverage on the city or the city's planning staff is under pressure to move a project forward. This is not conjecture. Our own councilman, Charles Slife, has publicly implored other city council members, as well as members of the City Planning Commission, to vote for the expansion, because if they don't, CCF might move the project out of Cleveland to their properties in the western suburbs. He also said in public that the project should go forward so the city so we, the city, don't get sued. And I'll reference that in a minute. It's frustrating when the residents have to contend with the noise of helicopters flying over their homes in the middle of the night for the last 15 years, even after the BZA disallowed it in 2010. The BCA disallowed it due to concerns of noise and safety. Even our then councilman, Marty Kane, urged the BZA to disallow it, and he also served on the board at Fairview Hospital at the same time. Prior to 2010, at University Hospital main campus, a helicopter left the roof of the hospital and somehow lost control and crashed on the ground below, causing 2 fatalities and severe burns on another who survived. CCF, being dissatisfied with the BZA decision, went to court and ultimately to the Ohio Supreme Court and got the decision set aside, again demonstrating its disregard for the BZA and the safety and security of the neighborhood in favor of its own convenience. Incidentally, University Hospital is zoned IR, and the district below, adjacent, across from the crash, is residential, kind of like ours. It's frustrating when our real estate appraisals have gone up tremendously and our taxes have risen similarly, and we see the actual property values and desirability of our homes decrease of institutional spalls and eyesores. Many ordinances that protect residential districts require screening from institutional or industrial activity. How can you screen an entire city street with 4,000 to 5,000 cars per day of traffic? It will be painful to watch our safest taxpayer-supported street handed over to the CCF for their convenience at our expense. There have been younger people with small children that have moved into our subdivision in recent years, only now to be confronted by the situation we are currently facing. How can young children play or ride their bikes safely when cars are streaming through all of the streets of our neighborhood looking for a shortcut to the parking garage? And perhaps the most discouraging reality is the fact that we have all made these sacrifices and have gotten absolutely nothing back in return. The fact that all we got was the degradation of our neighborhood and a neglected 10-foot wall that was converted into a slum by the hospital. Ah, yes, the green space. But we all know that green space is nothing but land reserved for the starting point of the CCF's next expansion to the east. If the hospital gets 179th Street, it will just accelerate their ultimate march eastward as far as it can go. In conclusion, we on to 129th Street and require the applicant to route traffic to and from the main artery on its own property as it did in 2010. The footprint of this expansion is bigger than the land that the hospital has. And as I said at the first meeting, that's their problem. It's not the neighborhood's problem. It is not our problem. We shouldn't have to contend with the hospital's solution to their problem.
All right. Thank you so much.
Yes.
I'll move now to you. Give your name and state your comments.
Your video.
The video was never shown.
Do you want to give your comments?
He's still got a short video he would like you to watch.
Yeah, did you watch the video that
Yeah, we got your materials.
Did you watch the
board
video?
had the
Only 5
opportunity to
minutes,
see
and I think
the
it's
the
really
video.
relevant for everyone to
This
see.
is relevant. Yes, very relevant.
I don't know if we're prepared to play the video at this time. But certainly the board has access to it and can watch it off the record.
If you would, because it is very, very important what you see in that video as to what the hospital actually thinks of our neighborhood and our people.
Excuse me, I think there's issues with the audio. I mean, it looks like the video is playing, but we don't hear anything.
It's not.
Well, here you can see the interior of the Cleveland Clinic owned home.
I wanted you to hear what the lady had to say. This is one of the houses that they live.
Yeah, hold on a second. Hold on a second. We can't have multiple people talking at once. So we're right now focused on the video. The video is just depicting the condition of a property. I think the point is pretty much well taken that you want us to see the condition of the property here in the video. And again, this is something that the board did have access to prior to this meeting. It was in our materials and we had the opportunity to review it. Now, did you have a question, Madam Secretary?
I believe this video was shared with us over the weekend, so you didn't have this one in advance.
You watched it then.
They weren't able to see that because we didn't get it until Sunday.
Oh, no,
This
no,
video.
that I submitted.
Yeah, it was a link
Oh, the
in
video
one
was
of the
in there? Okay,
materials.
I apologize.
All right. Oh, your mic is off. I'm not sure how long it's been off.
The other thing that wasn't brought up, I thought Katie would do it.
Hold on one second. I've got to get to the rest of the speakers who.
Well,
also
this should
have
take
to
2
speak.
seconds.
Okay, 2 seconds and that's it.
Okay. In 2019, there was a meeting with the hospital and the CAMS Development Corporation, and the councilman may have been there too. We have somebody in the room that was there. The meeting, essentially, the hospital presented its expansion plans. And they said, if we don't get everything we want, we're just going to move the whole project out to Avon. Kind of a threat, putting pressure on the city. So I wanted to get that point. That point should have been made earlier.
Okay, yes, I think we did hear that point. I'll now turn to you. You have the floor.
Great. My name is George Gorzay. I am the house and the business. Undoubtedly the most impacted by this project. Our councilman's life, since he got into office, I have been providing him with documentation on the Cleveland Clinic's behavior in our neighborhood, including photographs, videos. I started a neighborhood accountability email chain maybe 7 years ago. And I asked each member to start a file in their computer because I'm going to continue to submit them. I said, when we find ourselves at those critical junctures in our neighborhood, in front of the planning commission and the zoning board, we need to be prepared so that we can demonstrate exactly what kind of neighbors and how the Cleveland Clinic has acted in our neighborhood. Never received a response. Same thing with CAMS Development Corporation. Same thing with Department of Building and Housing. That's Ann's house. She lived there for, I think, 20 years. Hospital employee for 40. She rented from the clinic. Two of my neighborhood accountability emails that our councilman received were focused on her home. He had knowledge of not only her house.
I want you to address your comments to the board.
That's fair.
Thank you.
He had knowledge of not only her house, but of the degradation of the entire neighborhood. And he elected to do nothing. For him to sit at the planning commission and be a voting member is not justice. It's not justifiable in any way. We raised concerns about a conflict of interest. As he stood up in those meetings and was always the last speaker, just like in front of city council voting on the zoning change, he stood up and he literally had Cleveland Clinic pom-poms saying how good this is for us and how great the Cleveland Clinic is. And he said it. They will move out of the city limits. This was his pitch. Now, he has a responsibility to us to represent us in some way.
So I hear your comments. You're expressing concern about the councilman, but your
Okay.
your appeal is
Based on
focused on something a little bit different.
Correct.
So I want you to get to that.
Councilman's life is supposed to advocate for my family and my boys. He's been made aware of my boys' disabilities. And now let me tell you a little bit about my boys' disabilities. I'd also like to get in here right now that 2010 BZA, 1999 Memorandum of Understanding, I'm in full agreement and believe those need to be upheld. So I'm going to focus on my older son, George. Both my sons have autism. Georgie is level 3, Simon is level 1. Oh yes, and these scars on my hands and on my neck and on my face are a direct result of what he's going through with the changes in the neighborhood right now. And I have medical documentation to prove it. So, factual basis and medical evidence. Our son, George Gorzet, is a qualified individual with disabilities under the ADA. He has been diagnosed with autism spectrum disorder level 3, requiring very substantial support. Language impairment, cognitive impairments, OCD, anxiety, ADHD, and a history of seizures. These diagnoses are documented and supported by his developmental pediatrician, Dr. Catherine R. Shearer, DOFAAP, at Akron Children's Hospital. Dr. Shearer's professional letter, which is right there. Dr. Shearer's professional letter documents the severe harm that George has already suffered due to environmental changes on West 179th Street, specifically when the Cleveland Clinic demolished neighboring homes in 2024. During this period, George experienced the first 2 seizures of his life. He had never had a seizure before and has not had one since. This was also when his OCD patterns became unmanageable. His behavior became violent and he began having significant difficulties at school. Dr. Shearer further warns that the proposed routing of thousands of cars per day down our street will introduce even greater risk, such as increased noise, traffic, and the loss of safe outdoor space, which are likely to cause further regression and endanger George's health, safety, and development. Of particular concern is George's history of elopement and limited safety awareness. Dr. Shearer notes that George will run out of the house and into the street and does not respond when called. Any increase in traffic dramatically raises the risk of a tragic accident. We are deeply fearful that these new environmental changes could trigger additional seizures, behavioral crisis, or other severe setbacks for George, including life-threatening safety risks. Dr. Shearer states children with autism often rely on stable, predictable environments that minimize sensory stress and support structured routines. Any significant change in the surrounding environment, such as increased noise, traffic, density, or commercial activity, can cause severe anxiety, behavioral regression, and disruption to carefully established therapeutic and educational supports. The proposed commercial parking garage would introduce noise, light pollution, traffic, strangers, and loss of safe outdoor space, all of which are particularly distressing and potentially harmful to a child with sensory sensitivities and a need for predictability. Full letter there. This is from his education team. Educational evidence. In addition to medical documentation, Georgie's school, Steps Academy, has provided detailed evidence of his significant behavioral and safety needs. According to his educational team, Georgie requires intensive supervision throughout the school day due to unpredictable and impulsive behaviors, including frequent incidents of elopement, running out of rooms, the building, or even vehicles without permission or awareness of danger. Staff must physically position themselves between Georgie and the exit at all times. And the classroom environment is specifically arranged to block open pathways to doors. Despite this precaution, Georgie has recently exhibited multiple episodes of elopement and physical aggression, requiring coordinated crisis response to ensure his safety and the safety of others. The school notes that changes in routine, unclear expectations, or environmental disruptions, such as increased noise or unpredictability, consistently trigger anxiety and problem behaviors. These observations underscore that Georgie's well-being and safety depend on a highly structured, predictable, and low stimulation environment. Any increase in environmental stressors, such as the proposed surge in traffic and noise on West 179th Street, would dramatically heighten the risk of elopement and serious harm. Excuse me, I need to wet my whistle. Legal application. By approving a project that will funnel 4,000 to 5,000 cars per day onto West 179th Street, a narrow residential roadway directly in front of our home, the city has adopted a method of administration that denies our son equal access to safety, to the safety, stability, and use of his residential environment. This constitutes exclusion and discrimination under both the ADA and FHA, as it substantially impairs his ability to benefit from the city's programs and protections. His sidewalks, his street, his neighborhood, his neighbors. The city of Cleveland has refused to make the reasonable accommodation required by federal law, namely to adjust or reroute traffic to protect residents with disabilities. The relief requested. Vacate or suspend the approval of the parking garage plan as presently configured. Require modification of the project to ensure compliance with ADA Title II and the Fair Housing Act, including rerouting traffic flow away from West 179th Street and implementing protective design measures that safeguard residents with disabilities. Affirm that the city's zoning and planning administration must comply with federal civil rights law. My children are protected. Their civil rights are protective and enforceable by the Department of Justice. Autism, sensory processing disorder, ADHD, and epilepsy are all covered under the Americans with Disability Act. The Cleveland Clinic, Fairview Hospital, the administration at Cleveland Clinic, Dr. Neil Smith, John Mills, President and Vice President, they are fully aware of my children's disabilities. They have seen my bloody arms. They have seen what is happening to my family, my children. Kelly Mersman, Director of Planning for the City of Cleveland, is fully aware of my children's disabilities. The Planning Commission members are fully aware of my children's disabilities. I made them aware. My wife has made them aware. We have asked for conversations on how to mitigate the impact on our children. And no one is even willing to acknowledge that I have two federally protected children under ADA and civil rights. There's been no mitigation. There's been no conversations or acknowledgement. And as far as Director Mavich's, I wish he would have brought the slide. Maybe he did. When we met at the library, he showed 4 or 5 slides of traffic queuing. On every one of those slides, the queuing was done in red on our street. His queuing shows cars queuing directly in front of the entrance to my business and directly in front of my driveway. The plan is to block my home, access to my home, and access to my driveway. I couldn't believe I was looking at it. My sons will become prisoners in their own home. It will not be safe for my children to play in the yard, sit on the porch, even to come out of the house and get into the car because of the risk of, especially Georgie, just taking off. And no one wants to acknowledge that there's even a risk. And it's not acceptable. It's not acceptable for the city to move forward not willing to address these concerns. So, I need like 3 more minutes. Educational evidence, factual basis, and so, members of the board, I want to respectfully remind you, I got to back up. The law department is also aware of my son's disabilities. And every person sitting over there is also aware that that referenced field office, the A.M. Higley field office, that is a residential home. It is zoned residential. The city, I made them aware, week 1 of construction, that it is not zoned for that. And if there is some kind of variance or temporary use permit, please provide it. To date, they have not. The law department, our councilman, everyone sitting over there is aware that the construction project is acting illegally. They do not have a legal right to be in that home, and they're just allowing it. I feel like the law department here and the city is just shepherding this through. Zoning, residential house, they're running a field office out of it. On the lots to the north of mine, where 6 homes once stood. Last community meeting, they announced that right next to my house, they're gonna put up a 6-foot fence, screen it in, put 12 inches of gravel in, and make it a lay down yard with semis pointed and dropping off steel and huge equipment unloading and loading, another field office and parking. These are 6 residential lots. I've also made everyone aware of it. In the same document, Councilman Slife was fully aware of it in the meeting. I mean, you're coming out in support of something that is illegal, not to mention substantially detrimental to my 2 federally protected children. So, sorry, I'm very emotional. It's hard when you're not comfortable being away from your home because you have a 14-year-old son who's violent and who attacks. And my wife is tiny and he's big and she bleeds and her hair gets pulled out. I don't like being this far away. It's an all day, everyday thing for my family. So, members of the board, I want to specifically, respectfully remind the board that while the law department advises on matters of law, its opinions are not binding. The Board of Zoning Appeal is an independent, quasi-judicial body empowered to make its own findings of fact and conclusion of law. In this case, the law department is defending prior city actions that are now under dispute. It is not serving as a neutral arbiter. Therefore, I urge the board to weigh the actual record before it, including the 2010 BZA resolution, the 1999 Memorandum of Understanding, and the federal protections under Title II of the American Disabilities Act, and to reach its own determination based on the evidence, rather than adopting the law department's interpretation by default. The integrity of this process depends on the board's independence. At its heart, this case is not just about zoning and planning. It's about people. My wife and I are raising two sons with autism whose safety, stability, and sense of home depend on this board's willingness to look beyond politics and uphold the law as it's written. Federal ADA Title II, individuals requires that public entities make reasonable accommodation to prevent discrimination against individuals with disabilities. That obligation applies to every department of this city, including the law department. I'm asking the board, as the body entrusted with protecting the public interest, to exercise its independent judgment and ensure that Cleveland does not violate its duty to safeguard all of its residents, especially those who are most vulnerable. In addition, all supporting documentation of ADA protected disabilities and associated safety impacts is being submitted to the U.S. Department of Justice and the U.S. Department of Housing and Urban Development for formal review.
All right, thank you, sir.
Not
We appreciate your
opposing
comments.
hospital expansion,
Understood.
not opposing the zoning. It needs to be done respectfully,
All right.
and it hasn't been.
Thank you for your comments. All right, we'll now turn to the city. I know that there is some issue around standing, and I would love to hear what that point is.
Thank you, Madam Chair. On behalf of the city, the standing argument is that of those who have not filed originally, signed for their appeals, do not have standing before this board. You make the decision how you make, and we'll defend according.
Okay.
But the brief addressed it. It was those that were not original appellants and who did not sign and file their appeals. So
Okay.
the city presumes these three have standing. Thank
Okay.
you.
Are we allowed to
Understood. Thank you.
object like she did? What?
Yeah, that
I
was.
want
that
to
was my
object
question.
because those weren't being filed as appeals. That was just to show that the neighborhood is behind this movement, for the record.
Okay, understood. All right, who would like to speak next on behalf of the city?
We move.
No, you can stay.
I didn't get to speak.
Oh, there's Barbara.
Oh,
There's public testimony, so.
yes. Ms. Haas,
Sorry
we'll
to
give you the
interrupt
floor.
you.
Go right ahead, please.
Okay, sorry to interrupt you. I just wanted to make sure that you knew that I was supporting what my neighbors have said. They've all made really good points. I agree with everything that's been said here. I know that due to time constraints and other things going on, that I won't go over the same points again, but I do feel that that 2010 agreement is something that should be honored for all of our neighborhoods, and that we for this project already, and continue to do so for the sake of Cleveland Clinic. And all we're asking is some concessions for us as well. And the agreement was already signed years ago. We rely on that. If we can't rely on what has already been agreed upon, how are we going to figure out what we do as far as where we're going to live and how we're going to stay there or not, because of we have kids and things like that. This affects all of us. And as I said, you've already heard all of this, but it really does affect all of us to a huge degree. So please consider what we're saying, and I appreciate your time.
Okay, thank you so much for your comments. All right. Go right ahead, Director. You have the floor.
Good morning, Board. My name is Callie Mersman, Director of City Planning. The City Planning Commission's purview is outlined in Charter Chapter 76, as well as Chapter 341, our design review codes of the Cleveland Codified Ordinances. And our commission members take their responsibility around that charge very seriously. The Planning Commission's purview is to guide development, approve specific improvements and projects, and oversee the application of that design review code. And especially in cases like this where there's a lot of public feedback and disputes about what development can and should look like, they especially take that responsibility seriously. You will see as we go through this that there have been a number of public meetings, as have been alluded to, a lot of feedback coming in, and specific mitigations integrated into the finally approved development plans that respond to those comments and concerns. You'll also see that the Planning Commission itself has pushed the Cleveland Clinic to examine other alternatives and really defend the design decisions that they brought before the city. There are two main areas that we'll spend time on today. One is talking about the details of those design, how they've evolved from the beginning of the project to what was finally approved by Planning Commission, and the rationale and information that factored into the Planning Commission's decision. And then the second main area is the zoning that has been discussed and how our zoning codes and zoning practices apply to this specific decision.
Good morning, Madam Chair. Shannon Leonard, Chief Zoning Administrator. So I will walk through the zoning and kind of go back and forth here with the director. Maybe next slide. So the grounds of the appeal here today is a administrative appeal of the City Planning Commission. And so the standard of review for this board is whether the administrative decision by the Cleveland City Planning Commission was illegal, arbitrary, or capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellants fail to meet this burden, the administrative decision must be affirmed. And again, this is based on the charter of the City of Cleveland, as well as the Board of Zoning Appeals, Chapter 321.02D of our codified ordinances. Next slide, please. So I just want to give a little bit of procedural background. This has been a multi-year effort between the clinic, the city, and the neighbors, and the community, as well as council. And so these things kind of happened in tandem, right? There was first the clinic went out to the community, and then they came to the city, and then the council and the clinic came to us and requested a rezoning. And then at the same time as that rezoning process was going on, there was the new construction design review process. And so that change 2679, also known as Ordinance 86025, was adopted, which reclassified the subject parcels from local retail business and multifamily residential to institutional research D3. And that was under the codified ordinances of Chapter 333, which is the ability to amend the building zone maps. That was approved by the Planning Commission on April 4th, 2025, and it was subsequently approved by City Council on August 13th, and then it becomes effective for any permits pulled as of September 12th, 2025. New construction based on our design review chapters of the zoning code under 34102A and 34102C. That's for new construction of any institutional development and those properties located in the design review district that require City Planning Commission approval. These properties are located in the Cam's Corner Design Review District. The Cleveland Clinic and city staff conducted multiple community meetings with West 179th Street and council representatives. This resulted in modifications to the building massing, access management, landscape buffering, lighting, and others that will be discussed. And then on September 5th, 2025, after multiple public hearings, the commission found the project was consistent with the institutional research district and required design guidelines required under 341 of the codified ordinance. The project conforms with the zoning code and no zoning variances are required. And then obviously under 329.021, the neighbors appealed within the 30 days of the decision. Next slide, please. And so just to give you a little bit of context that was as it relates to how to amend the building zone map. So when there's a request to amend the building zone maps, that can come in one of three ways. That can be through a council request, a property owner / developer request, or it could be a city administrative staff, typically a strategic rezoning type of request. And all of those are available under the codified ordinances 3333, as well as our charter under 76.2 and 5. And it's a legislative rezoning. It's not an administrative. It has to go through legislation, which has to be adopted by the City Council of Cleveland. Next slide. And so this is the map change that we went through. The original request came into the zoning office around May 30th, 2024. That was the first request to rezone by Council and Clinic. It was submitted by the Cleveland Clinic and City Council to begin the rezoning process. This is typical of any major development such as this in the city of Cleveland. Those are the typical ways that it comes in. On December 20th, 2024, there was an information-only rezoning presentation to the Planning Commission. No decision was made, but it was out to the public. On April 1st, 2025, city staff, including myself, went to the community meeting to discuss the map change, 2679, and to gather public feedback. And then Planning Commission formally approved the map change on April 4th. And then the process worked through the summer in tandem with the design review and city planning process. The Development Planning and Sustainability Subcommittee approved the rezoning, as well as City Council as a whole on August 12th and 13th. And it takes generally 30 days for it to become effective for when Department of Building and Housing permits are pulled. Next slide, please. And so this was the previous zoning. It says current zoning. That was the current zoning at the time of the rezoning. What you'll see in the large pink to the south of Lorraine is the main Fairview campus with the parking garage that is expected to be brought down because it's old and aging and needs to be brought down per the city. And on the north side is where the mall center and the health center are, and where the campus expansion is intended. And so what you can see here is a mix of local retail, multifamily zoning on the site. You can also notice that to the west is the metro parks, where they are constrained by a riparian and wetlands, as well as the city's border. Next slide, please. And so the purpose of this rezoning was really to consolidate a variety of the zoning districts, a mix of local retail, multifamily, and single family into one comprehensive district. It was to ensure that future development meets the community needs and to align institutional investments with the proper zoning that complements the residential and mixed-use character of the neighborhood. And so what you can see across here is that the rezoning change the properties on the north and south of Lorraine from multifamily and local retail and single family to institutional research. That was really to allow for Cleveland Clinic's the property ownership to complement not only their own what they're doing on their own sites, but also to give the City Planning Commission and the city a little bit of more institutional control as it relates to future development, requiring a campus-wide plan and things of that nature. And then we also maintain the local retail. So as you go further east towards the shopping center on the north and south, is also institutional research, but also local retail to maintain the neighborhood amenities. In addition, we removed the specific map setbacks that were 15 feet on the north and south side, and that really allowed for them to bring the development towards Lorraine to provide a more vibrant streetscape, bring the building away from the residential neighbors to the north and to the east. And so that was the main intent of the rezoning that was adopted by Planning Commission, but also laid the regulatory framework for the development and design that you see going in at the City Planning Commission. Next slide, please. And so the other part is the new construction design review. So it requires City Planning Commission before any building permits can be issued. And that's really under 34102A, C, and E. A relates to design review districts. This is in the Cam's Corners Design Review District. This is new construction of institutional development as defined in this chapter, and that includes any new building for which such uses and associated accessory garage parking occupied at least 50% of the building. And then also anything that is in a transit-oriented development project. Those are any new construction in our transit-oriented development zones, and this is one of those zones. Next slide. And so this is giving you the list of design review steps. So in December 18, 2024, the project went for conceptual approval to the Far West Design Review. So you have your local design review that reports, advises to go to Planning Commission, where Planning Commission gives those actual approvals. December 2024, the Planning Commission granted conceptual approval with condition to continue community engagement and address feedback. April 2nd, 2025, Far West Design Review Advisory Committee gave recommended schematic approval with condition. As you'll note, on April 4th, 2025, when this is also when the rezoning was passed, they did postpone the case. They requested a full campus plan in line with the zoning, a traffic study for Lorraine egress, and a wildlife impact study. And then on May 2nd, Planning Commission granted the schematic approval with conditions. September 3rd, 2025, Far West Design Review Advisory Committee recommends final approval with conditions. And then on September 5th, Planning Commission granted final approval with recommendations citing intentional design, landscaping, and neighborhood appropriateness as the reason for their approval. Next slide, please. And so what's really important is when you're thinking about why does City Planning Commission make the decisions that it makes, it's based on design review standards that were adopted by the council as well as City Planning Commission and are kind of highlighted in 34107. And so under design review, they're looking at design compatibility. Alterations, additions, and new development shall be compatible in scale, material, color placement, and character with the design of the subject property, as well as design of properties that are represented as area's most valued architectural and environmental qualities. In evaluating compatibility, consideration is also given to the value of diversity and individuality of design. They're looking at contemporary design, understanding that all buildings are products of their own time. Alterations, additions, and new developments which have no historical basis and which seek to create an appearance characteristic of earlier time are not required. Conversely, compatible contemporary design is encouraged, except where such design would clearly detract from the architectural unity of significant structures. Preservation of features, this is new construction. Fences and other accessory structures, fences, walkways, lighting, benches, landscaping, and other accessory structures should be compatible in design with adjoining buildings and with the most valued aspect of an area's character. Use of chain link fences is discouraged. Parking lots, use of evergreen shrubbery and trees in combination with low ornamental fences is encouraged, and screening parking lots from streets. Use of curbed planted islands is encouraged to provide visual relief in large parking areas and to control traffic circulation. For districts characterized by buildings set along the street line, parking lots shall be located behind buildings whenever possible, entrances located off of adjoining side streets. And sustainability, buildings and properties should be designed and constructed to minimize energy consumption and to promote conservation of materials and natural resources. So that's giving you an idea of what the Planning Commission is looking at as projects for new construction, development, additions, things of that nature come to that commission when they're making their determinations on approvals. From there, I'm going to hand it over to Director Mersman to kind of walk through these items that Planning Commission dealt with. Next slide.
Thank you, Shannon. So the next several slides are taken directly from presentations that the Cleveland Clinic made to the City Planning Commission. We wanted you guys to be able to see the same information that they received. However, we'll go through several of them at a more rapid clip given timing, lingering on the ones that address issues raised and some of the key points of decision-making and mitigation along the line of the Commission's reaching to final approval. So this is the master campus plan currently of the Cleveland Clinic Fairview campus. Please move forward, Xavier. This is the overall site plan that the Cleveland Clinic brought to City Planning Commission as a result of that postponement in April and a request for more insight into the broader campus planning moving forward. Next slide, please, Xavier. This shows some of the ingress and egress that we have been talking about with that entrance off of West 179th Street. There are slides coming up that get to that in more detail, but I will highlight here that this location is right along a high-frequency transit line and is also within pedestrian access of several residents. providing the health care that this campus provides in an accessible way in addition to the cars that will be accessing the site. Next slide, please. These are some of the traffic analysis slides that were presented to Planning Commission when the Cleveland Clinic came back after being postponed for schematic review, showing the impacts, the adverse impacts along Lorraine Avenue of an entryway coming off of Lorraine and supporting the decision to have the parking garage entrance off of West 179th Street. Next slide, please. The clinic also walked the Planning Commission through the various pros and cons of different access entrances. There was some discussion at Planning Commission about why and how this was located there. At this point, I'm going to hand it off to Commissioner Mavic to talk about the traffic questions in more detail and some of the conversations that led up to this information being shared with Planning Commission to inform their decision.
Thank you. Yeah, we did. On numerous occasions, we met with the clinic and they provided their information and the studies and how this would actually work. It was the city's recommendation to use the 179th Street because of the impact it would have on Lorraine and the new garage with two closely spaced intersections. The other concern, and this was brought up when we met in our the meeting with the residents as well. Some of the other concerns were access if 179th were closed off to the neighborhood. That was discussed at that meeting about looking at having Lorraine and Old Lorraine rearranged so it'd pull the intersection further away from 176th Street, which then could be signalized potentially. And so we've asked the clinic to look at that particular intersection to see if that's a feasible solution. We have received a preliminary plan on that as of so far, but so we're continually working with them and had worked with them prior to the submission to the Planning Commission.
Thank you, Commissioner. So when Cleveland Clinic presented this to the Planning Commission for the final approvals in September, city staff had recently attended a community meeting talking about the final presentation. At that time, we discussed with residents in detail the neighborhood access needs and traffic management needs. And at the Planning Commission, the city's recommendation was to close West 179th to prevent cut-through traffic on the north end coming through the neighborhood to access the new garage and install a new traffic signal at an adjacent side street to allow neighborhood residents to access their homes and exit smoothly to address the concerns raised by residents, including Mr. Grossman. So as Commissioner Mavic said, those details and the detailed designs are continuing to proceed, but we have heard from residents the concerns about cut-through traffic, increased traffic volumes. The city did do those pre-counts that were mentioned before and have committed to continue to collect data to mitigate any adverse impacts to the neighborhood residents while achieving the access that the clinic facility needs through the design that is most consistent with the overall needs of the community and our design review standards. Next slide, please. I also mentioned in my opening statement that there have been mitigations and site design adjustments over the last 2 years as a basis stemming from the resident input received. So Shannon previously shared the community meetings as well as the public meetings that have been hosted to shape this design moving forward. As you can see here, in May, the initial proposal was a 7-level medical building and 6 levels of parking. That has evolved since then to the final proposal, which includes a 4-level medical building and a 5-level building with significant buffering along the west side of West 179th Street, as well as between the green space that the clinic owns and the residences to the east of the facility. So this is responsive to community feedback that was concerned about height, view shed, and overall massing on the site to make it as compact as possible and create those buffers and landscaping screening as much as possible. This also included a relocation of about 120 service providers from this site to allow the proposed service program to fit into the new proposed development. Next slide, please. Through the course of the Planning Commission's review of this, of course, going through our typical conceptual schematic and then final review stages, the Planning Commission also pushed the clinic to review some alternative means for entry and egress. One specific area of concern was the pedestrian bridge that connects this building on the north side of Lorraine to the existing Fairview building on the south side of Lorraine. The Planning Commission asked the clinic to review what it would look like to take that underground. The Cleveland Clinic did a comprehensive geotechnical survey and came back to the commission with information showing that that was not possible given the bedrock and the state of the geology in this area. However, this is indicative of the types of pressure that the Planning Commission placed on the clinic to do the due diligence to investigate all design options and to ultimately bring a refined proposal to final to the commission for final review and approval that really baked in all of the information that they were receiving from the design review advisory committees, the community members who came to public feedback, the documents that they received in advance of commission meetings for public feedback, and staff information, including the traffic data that we discussed earlier. Next slide, please. This slide again is excerpted from the Cleveland Clinic's final presentation to the Cleveland Clinic and shows some other of the design adjustments that have been made in response to feedback, including adjusting the building material palettes, the screening of the parking garage, circulation and wayfinding signage is proposed to help people navigate and to avoid too much circulation to really help people connect exactly to where they're trying to go. Extensive landscaping, including trees of specific heights and trunk diameter to provide that screening from day one, and a lighting and photometric study to prevent any light spillover from the parking garage, which was something else that we heard in detail was a concern from residents. Next slide, please. The clinic also detailed circulation from both pedestrian, transit, as well as vehicular going through the campus. And Xavier, this is where we're going to pick up the pace a little bit so you can just sort of smoothly flip through them and I'll narrate as needed. But all of this was supporting documentation to answer the Planning Commission's questions and support the decision to approve based on the final proposal, which was substantially altered from the initial one as a result of the input that the Planning Commission received. This will just give you an idea of what the building looks like, some of the treatments. We'll be getting into renderings in a minute. And Xavier, you can flip through them pretty quickly. I'll also note, if you could pause here. I'm sorry, I told you to flip. This shows the proposed encroachment onto the existing unimproved right-of-way that is an extension of Eileen Avenue. So you can see there, as Mr. Baird mentioned in his testimony, the city is in the process of formalizing an encroachment permit for the Cleveland Clinic to use that right of way for part of their access. Encroachment permits are a very standard process for us to permit use of right of way while that space is still retained as right of way. As Mr. Baird mentioned, this is currently trees and grass, it's landscaping, it's not any sort of improved access, but it still does remain in the city's right of way, and all public access is available. Please continue, Xavier. This shows the photometric study, keeping the lighting on the site. Materials of the building. You can go ahead to continue to flip through. The Planning Commission also was concerned about the impact on birds coming up from the metro parks in the valley, et cetera. The Cleveland Clinic did a wildlife study around treatment of the glazing to make sure that those adverse impacts did not manifest with the birds, and also to create some screening there's a glass staircase going up to the parking garage. There were some concerns about views into adjacent residents' homes, so they adjusted the glass patterning on those areas to really protect the privacy of nearby residents while maintaining the building's design features. This shows the different glass types that are proposed along the building given those different needs. The parking garage was also designed to prevent headlights from shining out at ground level and to be appropriately screened from the surrounding neighborhoods. And then you'll just see a series of renderings here of the new building along Lorraine and then up to the north along West 179th Street. This shows the landscaping screening proposed. And they also presented to Planning Commission sort of what the growth over time would look like. So you'll see that progression here as the installed landscaping has the opportunity to grow and develop. This is the mature growth. This is looking to the south from West 179th toward Lorraine. As part of the community conversations, the clinic's initial proposal did have an additional parking lot, surface parking lot on Lorraine on the east side of West 179th Street, and that was incorporated into the overall green space on the east side of West 179th Street to the north and south of Mr. Gorze's home. As a result of the community conversation, you can see that design here, as well as the healthy buffer of trees and vegetation backing up from the green space onto the residents who are fronting West 178th Street. The clinic also shared details of their fencing plans to establish that row of evergreen trees directly adjacent to the property line as soon as possible, even before construction is complete. So you can see the construction fencing there with the trees already planted and getting established to begin to attain their height during construction on the left side. And then the right side shows what full plantings would look like as they're transitioning out of construction into the green space. There are a couple of slides here about landscaping details showing the proposed plantings. And you can see, you can keep going, Xavier, but you could see in that last one, the proposed closure at West 179th Street at the top that would keep hospital traffic from cutting through the neighborhood on West 178th, 176th, et cetera. So it's really directing all hospital traffic to come in off of Lorraine Avenue. The slide shows the multiple community meetings that are outside of our formal city process. So Shannon previously talked about the meetings that were with Planning Commission specifically for conceptual review at both Design Review Advisory Committee and Planning Commission level, followed by schematic, followed by final. These community meetings were sprinkled throughout and were the impetus for many of the changes and the mitigations that we just walked through. We included here the motion forms from Planning Commission so that you can see the conditions and the rationale for their approvals. For final approval, there were several conditions recommended by the local design review committee, as well as some planning staff recommendations that were all incorporated into the final approval, as well as some requests for taller trees, even than you saw here in the renderings, to help formalize and jumpstart that buffer and landscaping screening. The commission ultimately moved to approve, given the mitigation strategies incorporated based on community feedback, as well as the appropriate context given the design review code for the surrounding neighborhood. I'm now going to hand it back over to Shannon to close us out.
Thank you. Just a reminder that the standard of review is whether the administrative decision by City Planning Commission was illegal, arbitrary, or capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence.
And your mic is off.
Okay. All right. So just walk through the grounds of the appeal here in terms of what the standard of review is for the board. Next slide, please. So the first question is, was Planning Commission's decision illegal? A decision is illegal only if the commission acted beyond its statutory authority or contrary to the express provisions of the charter or zoning code. The commission acted within its charter under 76.6 and under chapter 341 authority. Design review guidelines have been adopted by the city and commission. The commission conducted multiple public hearings, evaluated compliance with zoning and design standards, and approved the plan with factual findings supported by the aforementioned substantial evidence. Next slide, please. The second question is, was Planning Commission's decision arbitrary or capricious? A decision is arbitrary or capricious if it reflects no rational connection between facts and conclusions. The evidence presented here based on a reasoned and supported decision. There was an extensive public process, including 9+ community meetings between the clinic, council, development team, planning commission, as well as the city council meetings as it pertains to the map change. There's been a layered review, so based on Chapter 341, Planning Commission requires conceptual, schematic, and final design reviews. It was data-driven. It required traffic, campus, and wildlife studies before Planning Commission made their approval. Zoning compliance, the map change 2679 lawfully reclassified the sites here in question to institutional research, and there are no variances that the clinic is asking for. And in the findings on record, Planning Commission had cited community engagement, design compatibility, and alignment with city goals, as well as adopted design guidelines. Next slide, please. Was the Planning Commission's decision unreasonable? A decision is unreasonable if it disregards relevant facts, lacks sound judgment, or conflicts with the purposes of the zoning code. It is consistent with the adopted zoning. Hospital use and parking garage are permitted as main uses under the institutional research district. An objective evaluation was given. Planning Commission applying the design criteria in Chapter 341, the findings were tied to public safety, public health, and neighborhood character as a whole. There was evidence-based judgment. Approval followed traffic, landscaping, and other site studies. The public purpose is aligned. The expansion supports citywide healthcare access, as well as campus modernization goals in alignment with the citywide plan. And there was no unequal treatment or bias. The same standards are applied to similarly situated other institutional projects and new construction projects across the city. Next slide, please. Was Planning Commission's decision unsupported? A decision is unsupported if no substantial, reliable, or probative evidence exists to justify it. As stated previously, the Commission acted within its charter authority and under Chapter 341 authority, supported by all aforementioned substantial, reliable, and probative evidence to justify its final design approval of the project. Including in this report is detailed staff reports. There's been a traffic engineering review. There's been architectural renderings, public testimony, and all the other previous things that you have seen here today. Next slide, please. So there's been a lot of discussion about the 2010 Board of Zoning Appeals hearing. And so under the former zoning, it was zoned single family and multifamily residential. Since then, to this project, it has been rezoned as institutional research. And so earlier BZA variances permitting a surface lot were granted when the property was zoned residential, local retail, where hospital parking was otherwise prohibited. So that surface lot required them to come before you for a variance. Approvals were narrowly tailored and included the mitigating conditions that the residents have talked about here today. However, when City Council enacted the Institutional Research Zoning District, Ordinance 86025, that was a legislative act, not an administrative act. It superseded prior zoning and all variances attached to it. Variances and their conditions cease to have an effect when that restriction no longer exists. Surface lots are no longer invalidated under institutional research, right? It's a permitted use. And so those conditions, they don't need the variance. They're actually more in compliance with the code now than previously. So the new hospital expansion and parking garage comply fully with the institutional research district standards, eliminating the need for the variances. Next slide. And so in conclusion, City Planning Commission, the actual commission approved through a lawful, transparent, evidence-based process under the Charter 76 and Cleveland Codified Ordinance Chapter 341, following the legislative rezoning. The project meets all applicable standards under design review according to the Planning Commission and under zoning according to the zoning code. It requires no variances, and the project also advances and balances city's public health and economic development goals, as well as tries to balance that with neighborhood concerns. And so the decision, we believe, was reasonable, lawful, and supported by substantial evidence. And so we ask that you affirm the Planning Commission's decision and deny the appeal. Thank you. You can go to the next slide.
Thank you, Madam Chair. A lot's been said, so I will do my best to keep it brief. But what I would like to do is just help kind of explain the macro circumstances that have gotten us here. They've been alluded to in a lot of ways, but I think it'd be helpful just to give that context and then speak specifically to the zoning change and the design review decision from Planning Commission. So in the larger context, essentially the Cleveland Clinic facilities, including Fairview, west of the Cuyahoga River, all the way out to Sandusky, operate almost as a subsidiary of the Cleveland Clinic. And my words, not the Cleveland Clinic's, is essentially that Fairview is the kind of flagship campus, the crown jewel, and kind of Cleveland Clinic West. So there's a lot of symbiosis between all of these different facilities and where healthcare is offered. And what's great about Fairview Hospital is its location in the city of Cleveland benefits the neighborhood, as well as it was mentioned that there's a 24-hour bus line through some of the densest parts of the entire city on the kind of the Middle West side that allows people to access healthcare at Fairview who may not be able to go to a facility elsewhere in the clinic's network. The challenge that the hospital is currently facing, and that was brought to the city, is that if you enter the current property, there's a parking garage and an attached medical office building that are attached directly to the existing hospital. The parking garage and the medical office building are approaching end of life, and there's a need to replace those facilities. And the ability to do that in a dense urban environment requires some staging of building a parking garage prior to a parking garage is demolished, and building a new medical office building prior to removing medical services so that there's a continuity of services. Also, and I can't recall the exact number, but hundreds of clinic employees at Fairview currently park at the IX Center and are shuttled in because of parking constraints on the campus that have, I suppose, incentivized some people, and they're not supposed to do it, to park within the neighborhood. Illegally, we have asked for enforcement, and that certainly is a frustration that the neighborhood has experienced. But within the context of Fairview being part of a larger system, the acknowledgement from the city of Cleveland and that was brought to us by the Cleveland Clinic all along has been acknowledging simultaneously the challenges of developing in a dense urban environment versus the availability of land elsewhere already owned by the clinic, and a real concern that predates my time in office, that there was an incentive for the clinic to begin to downsize Fairview Hospital, relocate healthcare services outside of the city of Cleveland, which would not be beneficial to our residents, to our neighborhood, and I don't think anyone's advocating for that. The two guiding principles that I've had throughout this entire endeavor have been retaining healthcare services in the city of Cleveland, essentially doing a one-to-one replacement. We're not seeking to expand the hospital as much as we capitalize the hospital, but then also doing so in a way that acknowledges it's being done in a dense urban environment where there are residents and where we need to be respectful and cut against the adverse impacts that any new development could cause if left unchecked. Speaking specifically to the zoning, in working with the planning staff, the reason we determined that an institutional research zoning for all of Fairview's campus, not just the land that's being proposed for new development, would be beneficial. A large component of that was the institutional research zoning allows the city to compel the property owner to provide a master plan of their campus. Essentially, you're designating a campus and you are asking, we are able to say, moving forward, present us with your future development plans, and the city could deny future development plans merely for conflicting with master plans presented to the city previously. So the city now has the authority to do that. I also want to note that we very intentionally did not rezone any of the residential properties, including properties that are currently owned by the Cleveland Clinic that are proposed for green space east of east of West 179th Street to make every effort to preserve the existing residential character of the neighborhood. I cannot stand in the way of private property transactions, but in my conversations with the Cleveland Clinic, they've said that they have no intention to encroach further into residential areas. And I would note that the proposed construction would be followed by the demolition of the current parking garage and the current medical office building, which would create developable land immediately adjacent to the hospital that would become essentially a surface parking lot as the new end use. Pivoting to the design review, Director Mersman went through a lot of the elements of how the Planning Commission worked to scale back the building, ask for clarifying information, respond to some of the residents' concerns. I want to note that beyond the actual property line, many of the concerns that we're hearing about, which I think are understandable, about traffic and other things occurring in the public right of way that are not components of a building permit that would be issued to the property owner. Those are things that the city of Cleveland is needing to respond to, and that I am partnering with the administration to make sure that we're doing. Two key components that were mentioned about that were essentially barricading or blocking off access on West 179th Street into that northern cul-de-sac. Vehicles on that cul-de-sac could still egress out through other streets, 178 and 176, but that would prevent people coming through the neighborhood or exiting out through the neighborhood that are coming to or from the Cleveland Clinic property that have no real need to be on a residential side street. Absent that sort of barricade, I'm not aware of any mechanism or regulatory way that we can prevent traffic on a public street from turning left versus turning right. But the barricade would essentially compel people to comply with that desire. That would also necessitate the inclusion of a new traffic light on Lorraine where there currently isn't one. And then we've also been having conversations about not just passing legislation require residential parking permits to park on the street in this area, but the director and I are actually having conversations about updating that legislation. The way that it's currently structured is that it is something essentially that residents pay for through their taxes. That's how it operates, I understand, in places like University Circle and Ohio City. Across the board, I think that we've had a greater recognition that the value of parking varies neighborhood to neighborhood, and we're trying to find a way that we can have a more cost-effective, or I would hope even cost-free way to create a residential parking permit zone that is not going to, in the current structure, essentially we would be causing the residents to have to pay for that. I don't think that that's fair, and I don't think that that's where we would like to go. Also, I want to add that one of the things that the Planning Commission included in the approval would be a cutout for a guaranteed off-street parking for Mr. Gorzay, since his street would see more traffic and the driveways are rather small, they're tight lots, to give him the ability to continue to have guests and have a place to pull over that could be signed for, parking only as well, if he were to, choose to find that something that would be helpful. All in all, as I've said, the principal goals were to recapitalize the hospital, maintain the health services in Cleveland, and find a way to do it in a way that is going to be as respectful of the neighborhood as possible. Obviously, there are challenges when it comes to building in any dense urban environment, but I stand by this process. I believe that the clinic has responded to as many of the requests that the city and the residents have given as practical, but appreciating that the ability to modify the project to every single request would begin to jeopardize the ability to actually retain the health services in the city of Cleveland that we're trying to retain here. I'm happy to answer any questions about the process, and thank you for your time.
If you want, Madam Chair, on behalf of the city, if this appellants want to respond to anything on behalf of the city, I would just sum up basically our request at the end, which would be to uphold the City Planning Commission's findings and decisions. Thank you.
Will also be about.
Well, mine's pretty simple.
Wait, you have to talk.
Oh, okay. George Gorzay. They haven't answered to my appeal. My ADA grounds, my FHA, my protected children. That's the basis for my appeal, and no one addressed it. No one addressed it.
Thank you. I'll give the city an
Madam Chair, the city did respond in its brief that that we believe we've addressed that. Thank you.
I can also, the appeal is of the Planning Commission's design review approval decision. And so we responded in kind from the Zoning and Planning Commission standpoint.
Thank you, Madam Chair. The city would argue that there has been no violation of any federal law. There's been no violation, as well as there's no project or program that is in violation here. I have no other response other than what we filed, and that the city believes that it is not in violation of any federal, state, or local law on this matter. Thank you.
All right, thank you for that. Go ahead.
The city is a public entity, and this project removes safe access from two federally protected children. The city does have an obligation to at least, at the bare bone minimum, have discussions with my family, as does the Cleveland Clinic. It's clearly stated in both ADA and FHA writings and decisions. I have asked numerous times of every level of this process to acknowledge the impact and offer some kind of human, you know, what people here, we're talking about kids that are going to be put in the line of fire, already suffered negatively due to the lack of acknowledgement of my children's civil rights. And the zoning board voting members, I believe, hear what I'm saying and should suspend approval until this project has received ADA compliance. They're worried about bird safe class. What about children safe streets?
Thank you. I'll give an opportunity to either of you to give additional comments, state your name and give your comment.
Yeah, Walter Grossman. And the fact is, we're not appealing the buildings and the expansion. We're appealing 179th Street. As far as what they said, these neighborhood meetings that the hospital held, in every single one of them, there was massive opposition to using 179th Street. The hospital made no difference. They kept planning to use 179th Street. So these meetings were just a formality. They didn't accomplish anything. They didn't care what we said. As far as the Planning Commission goes, all the objections that we made were ignored. They were never discussed openly at any of the meetings. And the biggest objection of all is there for an expansion this massive, there was no official valid traffic study. There was no TIS, traffic impact analysis. I mean, that alone should qualify the whole thing to be put on abeyance or just require it to be changed. And like I said before, the lack of proper access and egress to the parking garage should be absorbed on their own property. That's their problem. They're making it a neighborhood problem. And all these suggestions, oh, we'll put a light at 176. You yourself mentioned at that last community meeting, well, I don't know if I have the money to do the light on 176. Well, what if it turns out you don't? Then we get stuck with the problem of how do we get out of our neighborhood safely. If 179th is blocked off, we have no access to 179th whatsoever. If it's not blocked off, then all this traffic is going to be coming through our neighborhood with little kids and everything. I mean, this is the major appeal that we have. And the fact that the parking garage is now institutional research still doesn't give the hospital the right to hog the whole street. And if it's blocked off, they won't have the whole street. They'll hog the whole street. We'll have no access to it. So this is my main objection to what was proposed here. They can design it all they want. We don't like it, but you know what can we say against that? That's their property. But when it involves our property, our city property, we object strenuously.
Okay.
Thank you
for that. Mr. Bear?
Douglas Baird. I'll just follow with what Wally has said. The problem is West 179th Street. In 2010, we all fought to protect a residential district, and we were awarded a BZA resolution to ensure traffic did the least harm to the residential district. And I respectfully disagree that changing the zoning voids that BZA resolution. We attended every meeting. We have made our thoughts well known in writing and verbally. The clinic has designed a building that does not fit on their property. I have never said that they should put the entrance to their parking garage on Lorraine Avenue. They have a curb cut, and they're taking 200 feet of West 179th Street for traffic. They need to use their curb cut, and they designed that originally. It was one of the proposals, and have a 200-foot drive so that the queuing traffic could stack up on their own property. Instead, they have proposed to not only take our street, but now the right-of-way gets magically absorbed. And by the way, we fell for this last time with the BZA approval when we were told the residential zoning on the west side of 179, that's not going to change. Don't worry, they can't build a parking garage here. That would require a whole bunch of public meetings. Well, they did it. They called the clinic down, the BZA, and said, you need to tell these neighbors what your master plan is. We have no further plans. We have no plans for the east side of West 179th Street, and continued to buy up the houses. They told us, we have no interest in your cul-de-sac. We're not interested in those houses. And they bought one. So with all due respect, we're fighting for our neighborhood again and again and again. In the city, I understand we're not standing in opposition to them building this parking garage. We are in opposition to our neighborhood being continually used as the sacrificial lamb that gets chopped up, eroded, and they don't do it nicely. They let the houses sit and rot, and then we as neighbors have to ask ourselves, do I continue to invest in my home? We made promise to the city of Cleveland when we bought our homes to maintain them, to pay our taxes. We're asking that the Cleveland Clinic be held responsible and that our promise is also kept by the city, that they in turn will protect residential from institutional zoning. We're just asking for barriers. It shouldn't be blurred this way. And the city keeps allowing them to do it. And it's frankly disgusting and disheartening.
All right. Thank you for your comments. I'll turn to the board and see if there are any questions from the board.
They all left.
No, we're still here. I don't have any questions at this time.
All right, thanks, Ms. Holzer.
Madam Chair, sorry.
No, that's okay. Go right ahead, Ms. Faith.
Second to get off of mute. Councilman Slive's statements were breaking up a little bit for me. And so I'm just, I think I caught the fact that there are no future plans for development going further east of 179. Is that correct?
Miss Faith, can you hear me now? I'm trying a different microphone. Is this better?
Yeah, that's better. Thanks.
Okay, yes, so to state what I had said, the Cleveland Clinic has said to me that there are no development plans beyond what is being proposed at this time. And I want to acknowledge that at this time, like what could happen 20, 30 years from now is not something that I think anybody can project accurately. However, there are no plans being presented to the city of Cleveland at this time, and there are no additional plans to alter any zoning in the area that would accommodate future institutional expansion beyond property that is currently zoned for institutional research.
Okay. And so those parcels that are on the east side remain and shall remain zoned residential. Is that correct?
Xavier, you can go back to the zoning map.
Shannon, just for the record, your microphone is breaking up a little bit.
This.
Yeah.
Maybe.
It's going in and out for me. I don't know if it's going in and out for Ms. Faith as well.
Yeah. Shannon, go ahead and talk and let's see if we can, if we're okay with it.
Mm-hmm.
I'll use both. Can you hear me now?
Great. Yes.
Yeah, this is fine. Go to the next slide, please. So this was the rezoning that you can see here. So on the north and south sides of Lorraine, closest to the riparian setbacks in blue, along the metro parks, is institutional research. Going as you go east, north, and south of Lorraine, what you'll see is on the east side of West 179th Street, that remained a single family district. And that does protect the neighborhood. It also protects them from the clinic because anything beyond open space would require them to come back before this board or go through another legislative rezoning. And then as you go down Lorraine, north and south, some of those are clinic properties. Those are, I believe, either green space on the east side of West 179th, instead of being a parking lot between Mr. Borze's home on the northern part, that's also going to be part of their open space buffer. And then as you go further down at the intersection of the Old Lorraine Way on the north and south, those are currently, I believe, parking lots, but they could be future development at some point. We have no control over that if the property owner chooses to develop. They would have to come back before the planning commission for any new construction if they were to provide any other amenities to their site. And then local retail further at the corner of Rocky River, south of the shopping center district that you see to the north.
Okay.
Yeah, so if I could, Ms. Faith, I need to clarify because that's an important clarification. The Fairview Hospital owns, or the Cleveland Clinic owns land that is now zoned institutional research and local retail, the lighter blue along Lorraine. It as well as residentially zoned properties on the east side of West 179th Street that retain the residential zoning. So the only expansion that Fairview could do at this point would be within the institutional zone or theoretically within the local retail zone. It's not contiguous with the hospital, but they're not able to encroach into the residential zone properties they own at this time. And I, as the council member, I've said to them, and I will say publicly, would not support legislation to zone anything currently zoned residentially otherwise.
Okay, so we're talking on the south side of Lorraine, that area that's parking lot and by Citizens Bank and that stretch of.
Yes.
Yeah, okay, all right. And just to clarify again, at this point, we have nothing concrete in the plan to block off 179th at the north or to install a new signal at either 176 or 178. Is that right?
And I think as we address this, can we go back to the map that has the traffic pattern and flow?
That has been proposed. There's nothing in the actual plan that shows that.
Okay. And are we close to moving in that direction or what's the status?
The traffic light is a non-issue that would be installed if 179th Street was blocked off. That has been made clear. However, we've not come to the conclusion that 179th Street will be blocked off.
Okay. And whose decision is that?
We're working with the residents on that particular issue. There's a lot of things that can happen that we can work with them to close that street in order to prevent the cut through traffic, install another traffic light, rearrange Lorraine and Lorraine Avenue to make it more conducive for a traffic signal. We could leave 179th Street open. So there are both options that are out there.
Ms. Faith, if I could add, this is Councilman Slife. Ultimately, those are city requirements. Those are not actions that would be taken by the Cleveland Clinic because it is city right of way.
Right.
It maintains its status as city right of way, even if it were barricaded, and that is not being proposed by the Cleveland Clinic. And at risk of speaking on their behalf, what they've said to me is the closure of West 179th between their property and the residential area is they have no opinion one way or the other on it. It doesn't affect their project one way or the other. So they are not proposing that. That is being proposed as a modification of the road network by the city of Cleveland, alongside other ideas like the traffic lights, traffic calming, residential parking, and other things to help maintain the calm nature of the residential streets.
So speaking in that vein, Ms. Faith, if you don't mind, just because we're on the topic, has it been considered to, instead of having the traffic pouring out on 179, have it come out behind the building and go out like around the other way? Because it seems to me that the most concern is around traffic just consuming 179, especially at like a rush hour. I think I know very firsthand how that goes, especially on a street that is so small. So I guess the question is, you know, can you just reroute the traffic to go around the building and then come out on Lorraine so that it's not imposing on 179?
I'll let anyone else jump in if they'd like. There is a need that we have been shared with us by the fire department to maintain access around, so that what you are proposing would not preclude a fire engine from coming through, but it could make it more complicated. Additionally, you can see where the building comes perpendicularly off of Lorraine and then kind of turns into diagonal. The opposite side of that is a retaining wall, as the cliff into the valley is right there. So I think there are also concerns about being able to have a wide enough and a durable enough road that is to handle recurring traffic in lieu of what is really being proposed for right now is fire access, and there would be like a paratransit type vehicle ability to drop off on that west side of the building and then be able to loop back around the property. Is there anything else anyone would like to add?
Ask them to look at that. I don't know that we have a solid answer on. That question has been raised as it relates to how that would work. I don't know that it can work. We've been told that it cannot from the clinic. I'm not part of their design team on the inside and how they develop their buildings. Our concern is really on the actual roadways, but that has been asked.
If I may?
Ms. Faith, go ahead. Hold on a second. The board member has the floor.
Thank you, Madam Chair. Yeah, it raises, you raise an interesting point, particularly with regard to paratransit service, of which I am intimately aware of. And so it would seem to me that the paratransit service is going to have to go one way or the other around the back of the building. And so just to clarify, the exit is going to be sort of at that curved area, and where's the entrance, the intake into the ramp?
That is the entrance and the exit. I believe it might be kind of a multiple lanes in out type scenario, similar to the Willard Park garage at City Hall. And then vehicles traveling in would be able to circulate directly into parking, or there would be an interior drop-off area sort of in the lower left corner of the garage, so people accessing the medical office building could be dropped off here. They could also alternatively be dropped off in the existing front entrance of Fairview Hospital, and there will be the connection over Lorraine Avenue to the new building.
Madam Chair, to Ms. Faith, if I may add, Ms. Faith, when the Planning Commission tabled or postponed the presentation at the schematic level for the traffic study and discussion of access, there were conversations like this with the clinic project team looking at alternatives. And so each of those, including going around the back, were discussed with the Planning Commission.
Sure. Okay. All right. Okay. Mr. Slife, probably you may be the best person to answer this. To your knowledge, has there been any discussion between the clinic and Mr. Gorze to move his house or rehome them to a new structure?
Actually, I might be the best.
Hold on one second. Can't speak out of turn.
Okay.
Mr. Slife, you have the floor.
Ms. Faith, as I've been told by my characterization, as I've been told by Mr. Gorse and the Cleveland Clinic, is that there have been conversations about acquiring. I am not sure the details of those conversations, values, anything of that sort, other than it's very clear that an agreement was not made between the two parties. That is not something that I have been involved with as the local representative and the representative of the city of Cleveland.
Now may I speak?
Hold on, I want
Um,
to see, let her answer her questions.
that topic, I was just curious about that. It really is not pertinent to what is before us today, but I was curious. So thank you for that information. That's all I have, Madam Chair.
All right, thank you, Ms. Faith. I'll give you a brief opportunity to respond.
Thank you. Yes, there's been conversation since 2004. And as this project progressed, the meetings picked up. The last meeting was June 26th of 2023. It was called by the hospital and it was in the conference room, in the administrative conference room. Present in the meeting were Dr. Neil Smith, the president of the hospital, John Mills, the vice president of the hospital and COO, and a gentleman by the name of Peter Volos, who is the director of real estate development for, I believe, the continental United States. Dr. Neil Smith used to be my personal attorney. We know each other. Oh, right, physician. God, no, not attorney. Of course, I was there and my real estate attorney, Hal Maxfield. And we had multiple offers, they called the meeting with updated documents. One was an updated land lease. One was an updated cash price. I'm just reading the documents. At this point, I'm so sick of the meetings that we've had that cost me $500 each time to pay Hal. And these guys are getting paid to be there. So I'm reading the documents. Hal says this land lease is crap. And the cash price is still way too low. So they had some back and forth. I didn't say a word. I'm sick of the meetings. I got 2 boys at home beating me up. I got a business I'm trying to run. And these guys have been messing around with me for 20 years. So they had some back and forth. I didn't say a word. And at that point, Peter said, okay, I think we have a better feeling of where everybody's at right now. We'll go back and talk to our team and we'll schedule another meeting. And at that point, I said, no more effing meetings. I said, I'm done with the meetings. And then I said, every time we have a meeting, boom, 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 we're not getting anywhere. I'm not coming to another meeting. If you want to submit an updated letter of intent, you do it to Hal directly or to me. But I'm not coming to another meeting. And then Peter gets all hunched up and he says, I don't understand what it is with you, George. Your reluctance to meetings and it's how business gets done. It's how deals get done. I'm like, no more meetings. At that point, Dr. Smith, who's listening in right there, A. Smith, he asked John and Hal to step outside of the conference room. So, of course I did. Now, Hal, my real estate attorney, and Neil, they knew each other coming up through, they played basketball together in the CYO leagues. So Dr. Smith asked me, George, is it okay if Hal steps outside? Hal laughed, patted me on the shoulder. He's like, you got this, and walked out of the room. The door closed. And I looked at Neil Smith and I said, sometimes it feels good just to let it out. Now, mind you, we know each other. We had conversations of him becoming president before he did, and the conversations the Cleveland Clinic had with him about me being his patient. So he looked at me and he shook his head with that smug smirk he has. He said, George, what's it going to take? And I said, you have my number. You have my number. And he looked at me and he held up a certain number of fingers. He said, this is for your family. I'm like, oh, thanks. This is for your family. I said, I want to hear you say it, Dr. Smith. Say the number. He said it. And I looked at him and I said, as you well know, in life and in business, I have a partner. And you need her signature every bit as much as you need mine. My wife, my rock. She doesn't want you to have it. You've been so horrible to our family and our business and this neighborhood. She wishes there was a way you could never have it. And you need her signature. I'll take her the number. If she agrees, we have a deal. He said, let me know. I have his cell phone number. So at that point, I went home, telling him about the meeting, exactly how it went. My younger son, Simon, he's jumping up and down. Mommy, 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 do we have a deal? My wife literally fell to the floor, crying and shaking. And she said, yes. I texted Neil Smith immediately, and I said, if you keep your word, in a text, I can show it to you right now. Correct date, everything. We have a deal. He immediately responded and said, I'm making the phone calls. 2 months later, he reneged. Had the power disconnected to the houses around mine. A big illuminating truck is in front of my house. I walked out, I'm like, what are you doing, man? I pay my bill. And he started laughing. He's like, no, I'm not here for you. I'm here to disconnect, not turn off. Disconnect the power to the house next to me. I'm like, why are we disconnecting power? He said, oh. He starts flipping through, and you can see the video. I shot a video of him. He's like, Cleveland Clinic's tearing all these houses down. I'm like, what? What? Did you have any knowledge of that in October? When the video was shot. So I shared the video. Cleveland Clinic's tearing all the houses down at Christmas around my kids. They're this illuminating company employee. So I shared the video. All of a sudden, that first meeting that they're touting as an engagement meeting was called by the clinic to explain not only to us, the neighborhood, but also to our councilman, Cam's Development Corporation, what the hell exactly is going on. Because, fine, they're their homes. They can have them torn down if they want. All you gotta do is pull the permit. They don't need permission from the city or from us. They don't have to let us know. But in the spirit of transparency and good faith, they should have had a conversation with our councilman and us. So then we had a couple more meetings, and then, we're going to tear the house down. The house is down. At that point, my son couldn't go to school due to stress and anxiety. He suffered 2 seizures in a 2-week time. He had recently been promoted into another program because they once believed he could have a more independent life than we once thought. But after the seizures and the trauma, that became evidently clear that he had regressed so much that they had to move him back down to the other school. And we're going through it right now. He didn't go to school today. He refused. Every day. He goes maybe 3 out of 5 days. He's afraid to leave the house. He says it weekly. This is our house. This is our house. As they're cutting holes in the wall. And the cars are flying out when we're taking our morning and night walks. And he's violent. So the answer, Miss Faith, is yes, we had a deal. The clinic reneged, and now is trying to spank my family as hard as they can, along with my neighbors, just to make a point that they can enforce their will, their influence over the city, the police, the media, and it's wrong. We had a deal. You know what this project would look like if they didn't renege? But I didn't want to go there. I'm glad Ms. Faith did. I think another important thing to realize here is there are options. They own multiple surface lots on Lorraine Road where they could build their garage immediately, alleviate the parking problem. And by the way, Councilman Slife, they are currently shuttling over 500 employees And that current garage, that's 995, is way, it does not give, they're gonna be shuttling employees after the garage is built. The current garage is 720 spaces. They lost 226 on a footprint where they're going to build. Where are those 500 employees going to park? They're currently being shuttled. I mean, the whole thing is it's a true documentation, a portrait of how Councilman's life was interviewed after one of the community meetings. The news was there. And in the meeting, it was said, Cleveland Clinic can do whatever they want. Here's another example of it in our neighborhood. Councilman's life stood there on the news, the 11 o'clock news, and said, I don't agree with the comment that the Cleveland Clinic can do whatever it wants. Well, here we are. This is a clear example of how the Cleveland Clinic is doing whatever it wants, and our city and its departments and commissions and boards just say, we need this project. Who cares about that guy's 2 kids and the rest of the neighbors? When's it going to stop? When are they going to have to act like they say they do? They were tasked by the Department of Justice to draft. I forget the exact name of it. It's about conducting business in legal and ethical and moral ways. I mean, give me a break. Look what's going on here.
Thank you. I'll now turn to Mr. Bay. I assume you have no comment, given we've already heard from the director.
Great.
Okay, perfect. All right, any other questions from the board?
Madam Chair, I just have one other quick question, probably to Ms. Leonard.
Sure.
Is there any issue with zoning or the construction company using that residential house as their construction headquarters?
Madam Chair, there is not, they have recently submitted a permit for that, and because it is zoned single family, if they choose to continue to use that house as a office for their construction as well as the construction laydown yard that Mr. Gorzi just explained, they will need a variance from this board. But for the project itself, as presented to the Planning Commission, which this is appeal is about, they don't require any variances.
And what about for their construction staging area that, where is that planned? Is that going to be using that, what is going to be green space? Or where is it going to be?
But their choice is to use the green space as their construction laydown yard, as well as the home to the north of the property. Both are zoned single family. When we do the adjudication on those permits, they will, if they choose to continue forward on that path, they will need to come before this board and get a variance in which you all can hash out at that time.
Okay, great. Thanks for that clarification. Appreciate it. That's all I have, Madam Chair.
All right.
Thank you, Madam Chair. Just very briefly, on behalf of the city, I think the director and Shannon did a fabulous job of going through the city's arguments, evidence, and presentation. And we would ask that you, based upon the entirety of the record, that you uphold this Cleveland Planning Commission September 5th, 2025 final decision in their case number FW 2024-14, approving the development and new construction at 18200 Lorraine Avenue, known as the Cleveland Clinic Fairview Hospital expansion, because the decision is not illegal, arbitrary, capricious, unreasonable, and has been is based upon a preponderance of evidence, substantial, reliable, and probative evidence. And based upon that, we would ask you uphold the decision and deny the appeals. Thank you, ma'am.
Okay, and then I just have one final question. Can we go back to the slide that articulates the design principles that are used in these cases? And I would love to hear how the City Planning Commission sort of made their decision around this particular principle. And I didn't memorize it, so I'll wait for the slide to come up. Yes, this is the one. Perfect. So if we look at letter G, and it said that the parking lots shall be located behind buildings whenever possible with entrances located off of adjoining side streets. Help me jive that principle with this sort of proposal here.
So when you're thinking about a urban environment and a streetscape and trying to make streets walkable, pedestrian friendly, eyes on the street, ideally you have parking lots lining buildings. You would want them to set behind the building. Alternatively, if you have a parking structure that hides that parking, that is alternatively preferred as well, right? And so in this case, what this is looking at is putting that, if you have a parking structure instead of a surface lot, one, that's more aesthetically pleasing, but two, it also creates that pedestrian walkability that the city is looking for across the board, regardless of construction, but also having, instead of having, when you're thinking about walkable neighborhoods and walkable streets, whether people are walking from the residential side streets up or otherwise, along Lorraine, you have two major bus stops. It's a high frequency transit way, as well as the transit oriented development zone. Ideally, you'd have the ingress and egress to parking structures or parking lots off the side streets, not off the main thoroughfares. And that's really because of the bus traffic and trying to provide a vibrant streetscape for pedestrians across the board.
Okay, so was it just that it didn't apply here, or?
So it is applied here. So they, instead of a parking lot, the clinic proposed a parking structure, which is a garage. And that's a preferred method of way of parking cars versus having just surface lots across the city.
Understood. So when there's a parking garage, that in particular,
And in
that
West,
principle does.
excuse, I'm sorry, say it again.
So am I understanding that if it's a parking garage as opposed to a parking lot, that particular principle doesn't necessarily apply?
It does apply in terms of wanting to have parking off the side streets versus off the major corridors, whether you're a parking lot or a parking structure, right? But the parking structure and the way that the clinic as well as planning commission requested is asking to screen that parking structure. And so there's several slides regarding the screening of those parking structures, as well as making it less overbearing, if you will.
Okay.
Do you want to add anything?
I'll just clarify to make sure we're absolutely clear that in this case, West 179th is the side street that access is directed from, with Lorraine is that main corridor. So that's how that section applies.
Okay. It looks like Councilman, you want to chime in? Go right ahead.
Thank you. We were not sure which microphones are working. In addition to what Director Mersman said, that West 179th is the side street, I think the next question then would be, when does one deviate from what is the design standard here, and why would you not have traffic ingress and egress directly from Lorraine? And in this specific circumstance, the challenge, the multiple challenges, including the density of traffic lights and essentially adding in another traffic light where there's already a number of cars coming in and out, as well as the concerns of cars driving in and out of a parking garage directly across a busy sidewalk, and essentially instituting a new curb cut that would incentivize cars coming in and out, but moving all that would create conflicts where you could have vehicle to vehicle crashes as well as vehicle to pedestrian crashes, whereas using West 179th Street allows cars to more successfully queue up instead of having to queue up directly as they're trying to turn onto a busy thoroughfare.
Okay, got it. All right. If there are no other questions from the board, I will entertain a motion.
Madam Chair, if I could remind the board that we do have quorum with 3 members, but there is also the language that we should state that in order for a motion to pass, it must be by unanimous vote, since we only have 3 members here today.
All right, thank you for that, Madam Secretary. Members of the board, I'll entertain a motion.
Madam Chair, first of all, I'd like to thank everyone who's present in person and online for their time and their participation today. This is a public hearing, and we always truly do appreciate everyone who takes the time out of their day to come down and speak on the cases that are before us. This has obviously been an emotionally charged and difficult case with a lot of statements by the neighbors and by city planning and the legal department. So we appreciate all of that. That said, what stands before us is the legal standard and the legal language by which we must base our decision. And with that being said, I move that we uphold the decision of the city planning and the design board.
All right, thank you for that, Ms. Faith. Do we have a second?
Board Member Holzer, I second.
All right, thank you, Ms. Holzer. Can we call the vote?
Ms. Holzer,
Yes.
Ms. Faith,
Yes.
Ms. Wilson.
Yes.
Calendar numbers 25-178, 25-195, and 25-199 are denied. The decision of City Planning Commission has been upheld. This decision will be ratified next Monday, and we will send the appellants a letter.
All right, that concludes this matter. Thank you so much for coming down and giving your testimony. We do have old business on the table, board, and I'm going to move to that right now. We have we have numbers 1 through 5 for old business that are up for ratification. Are there any objections?
No objection.
No objection.
I suppose I should call Marcus and Priscilla back.
We do have 3 members here, and all 3 were here.
Okay,
I
so
think
we
we have
can
enough
just
capacities,
ratify.
yes,
Okay,
absolutely.
all right, so numbers 1 through 5 will be ratified. It is 1:07. That concludes our business, and we will now adjourn. Have a great day, everyone.
Thank you.